We are live.
Excellent. Thank you very much. Okay, great. Welcome, everyone. Today is Wednesday, March 10th, 2021. We have, I think, 9 bills on the docket today. We'll start off with Senator Jackson with Senate Bill 918. We'll then move to 826, 760, 842, 867, 776, 864, 898, and then we'll wrap up with Senate Bill 910. Actually, I see that we have Senator Carrozza here. So Senator Jackson, if we could just get Senator Carrozza out of the way because she's so she can get back to her committee, we'll skip ahead and we'll go to Senator Carrozza with Senate Bill 826. Let me unmute you here. There you go.
Okay. Thank you, Mr. Chair. Are my witnesses on as well? I just, if I could confirm that.
Yep, I see Mr. Demeritus, and I saw Ms.
No,
David.
that's a different bill. I had Lieutenant Bornman. Lieutenant Bornman and Kim Tall were my witnesses.
Okay, let's let them. I see Mr. Pennock is here, and let's.
They're all on.
You're all on. Kim. Yep, you're all here.
Thank you, Mr. Chair. I really appreciate the courtesy, and I thank all the members of the distinguished Senate Judicial Proceedings Committee to present to you and ask for your support for Senate Bill 826, handgun permits qualifications for high-risk occupation. And this allows a handgun permit to be issued based on specified employed high-risk occupations, including firefighters, correctional, parole, and probation officers, certain healthcare, emergency medical, and rescue personnel. As this committee well knows, current law permits that an applicant for a handgun permit must, among other requirements, have a good and substantial reason to wear, carry, or transport a handgun. Good and substantial reason includes a finding that the permit is necessary as a reasonable precaution against apprehended danger. Senate Bill 826 would permit specified high-risk occupations to be included as a sufficient reason to hold a handgun permit. This legislation is essential for our public servants and first responders as it gives them security and the ability to protect themselves in high-risk environments that they face on a daily basis. Mr. Chair and members of the committee, we expect and sometimes take for granted that our first responders and other high-risk public safety professionals will be there for us 24 hours a day, 7 days a week, especially during the COVID-19 pandemic where they're doing even extra duty. When they are called into action, whether at their workplace or on a scene, our frontline responders put themselves in a position to assist in so many different scenarios. They go into drug and criminal areas to respond to the call. They have faced violent acts on the scene of an overdose or someone coming out of a seizure, or angry and disgruntled family members who sometimes lash out when they lose a loved one. Our frontline workers, our heroes, put themselves in harm's way in life-threatening situations each and every day. The high-risk occupations set forth in this bill fully satisfy the Maryland State Police's existing requirements for an assumed risk position. These frontline heroes should not have to actually suffer an attack or prove actual documented threats in order to secure a permit for personal protection. We should support our frontline public safety professionals working for us in these high-risk occupations and allow them to protect themselves. Mr. Chair, I'm happy to have Lieutenant Eric Bornman from the Ocean City Fire Department, as well as paramedic Kim Tall from the Ocean City Fire Department, further elaborate on the reasons for this legislation. I believe that this legislation is a reasonable request given the potential harm these high-risk occupations face to protect and serve our home communities. And I respectfully ask my colleagues on the Senate Judicial Proceedings Committee for a favorable report for Senate Bill 826. Thank you, Mr. Chair, and thank you for the courtesy.
Excellent. Thank you very much, Senator Carrozza. And I have Mr. Bornman as your primary witness. And so, Ms. Bornman, you're up. You'll have 5 minutes. Welcome.
Thank you, sir, and thank you to the committee for hearing our testimony. My name is Eric Borneman. I'm a lieutenant with the Ocean City Fire Department, and I'm speaking on behalf of myself, not necessarily for the municipality itself. But I appreciate your time to listen. As this bill presents, all the frontline first responders, not just in a 911 setting, but healthcare workers as well. We have a high-risk public safety exposure. We have interaction with known violent or potentially violent individuals that reflect on our identity. The current wording and procedure to issue a handgun permit for concealed wear and carry, I or any one of the above mentioned individuals, whether it's a nurse, nurse practitioner, fire EMS provider, parole and probation officer, or a corrections officer, or a volunteer that's serving as a security personnel for a church or religious organization. We have the burden of providing a good and substantial reason for issue. With that burden of proof, it assumes the apprehended danger or the risk. Depending on your definition of danger, in our profession, we're exposed to that all the time. And we're not limited to just when we're on duty in that role. Depending on your definition, these dangers present many ways, whether they're disgruntled on their perception of what we do or don't do and what they think needs to be done versus what the protocols in the state regulate us to do as a medical professional. Or the environment of the call, we respond somewhere and we do something that's not necessarily accepted by an individual or a group that we respond to. By the Freedom of Information Act, and as a public servant, our information about our work schedules and other basic information is available that can be used to identify us for retaliation on that. It doesn't necessarily have to be on the scene directly. They can wait until we're off duty and meet us while we're going to our car or in traveling back to our residence, to our family. When we're observed at the scene, our identity and information is not protected, which can also result in the off-duty conflict. And with our favorable review of this bill, this would allow us the protective measure as a last resort, should the situation warrant it. No one hopes to eagerly use this as a line of defense, but that defensive mechanism should be available to us if the situation warranted and met with the training that we would pursue with that application of the permit. The legislation acknowledges that all of us have had verbal threats made, and sometimes physical threats have been carried out or gestures made either on the scene or afterwards during our career. And with our experiences, we directly have threats engaged with individuals. Many times it goes unnoticed or overlooked. It's not just a prisoner that might be getting transported. It's somebody that might be on house arrest with some form of intoxication that says to wait. You just wait until I get done with this and I'm going to come find you. We don't know the extent of what that may or may not be carried out to, but it is legitimate in the eyes of the law at that point. When a patient says to just wait, we don't know when that's going to happen. When we're leaving work or when we're arriving home, again, because our identity can be made. Unfortunately, with HIPAA, this also limits our reporting abilities in the medical profession when we get to expose that information at times. It doesn't necessarily make it clear that we can provide certain details as it involves patient care with those regulations. I do appreciate your time, and I would strongly encourage and request your favorable review for this as a last step measure that would extend to all of us in this high risk setting because of the exposures that we do face day in and day out on the call. When we go to work, we don't know what we're going to encounter. And when we do encounter individuals or certain situations, we don't know what that outcome is going to be because of other people's interpretation on the scene and the interaction that we perform. As much as we try to do that diligently and professionally with the stated protocols and guidelines that we do follow, everybody has a different opinion and an interpretation of what can and needs to be done. And that doesn't always go well in some instances. Thank you for your time. and I appreciate your efforts.
Excellent. Thank you very much, Mr. Mormon. And next up, we have Ms. Tull. You are up next.
Thank you, Committee Chair, Vice Chair, and members of the Senate Judicial Proceedings Committee for the opportunity to speak and request your favorable support of Senate Bill 826, Handgun Permits Qualifications for High-Risk Occupations. My name is Kimberly Tull, and I am a full-time firefighter paramedic with the Ocean City Fire Department. As a municipal employee, I am not representing the Ocean City Fire Department. That is just simply where I am employed. But I do appreciate this opportunity to speak and request your support for this important legislation. I've been in the fire and EMS service for 29 years. As a single mother of 2 boys, I am always concerned with our personal safety. Our uniforms are required to display our names, and with the internet and social media, it would take someone less than 5 minutes for them to figure out where my family resides. The current political climate is not favorable for public safety, and the nature of the calls that we run in fire and EMS are challenging. There are many days where I read that fire department employees are threatened and assaulted while on and off duty. Our firefighter close calls website just this week on March 7th, an FDNY paramedic needed 4 stitches to her face after being bitten by an emotionally disturbed patient in Brooklyn, an attack that she will recover from physically, but that will leave her scarred for life. Law enforcement sources say that Thursday night's case was just the 3rd attack in the last month. Another EMS member was bitten on the thumb during a February call on February 27th, and a firefighter responding to an EMS call was slammed into a wall earlier this month. I have been both assaulted and threatened while on EMS and fire calls in the town of Ocean City and other places where I have volunteered or worked. Additionally, EMS and fire occupations have known access to narcotics, both on and off duty, which is known by criminals and habitual addicts, placing us at additional vulnerability with limited safety options. We should not actually have to suffer an attack or prove actual documented threats in order to secure a permit for our own personal protection. I believe this is a reasonable request given the potential harm that we face to protect and serve our communities. I respectfully ask for your support for Senate Bill 826, and I appreciate your consideration. Thank you very much.
Excellent. Thank you very much, Ms. Tull. And next we'll have Mr. Pennick. Mark, you're up.
Thank you, Mr. Chairman. Mark Pennick, President of Maryland Show Issue. So you have our written testimony, and attached to that written testimony is the Maryland State Police Standard Operating Procedure with respect to the issuance of permits. There is a presumed risk category here, and it already includes people such as judges and lawyers, and by implication, if not expressly, includes every member of this committee. They're all special. And yet these individuals must come hand in hand, who face real risks, and you've just heard it, to this committee and to the state legislature to ask for permission to protect themselves, even though they face risks on a daily basis. There's something very wrong with that. So the Maryland State Police apply this assumed risk in a very restrictive way. And even though they have heard over and over and over again tales of people who have been assaulted, who have been threatened, they require a police report. Even though each one of these groups that are in this legislation actually suffer risk and threats constantly. So these individuals are forced to come to this body and ask for permission to protect themselves in a way that will control the unbridled discretion and arbitrary discretion of the Maryland State Police. I think that's reprehensible. Everybody has a right of self-defense, and sooner or later the courts will impose it upon Maryland, just as they imposed it upon the District of Columbia. 42 states. In 42 states, these individuals would be able to get a permit under objective criteria. District of Columbia, these individuals, the firefighters who live in Ocean City, would be able to go to the District of Columbia if they live there and get these permits to this day. And yet in Maryland, they are denied this basic right of self-defense. We urge a favorable report.
Excellent. Thank you, Mr. Pennick. And with that, I think that concludes the testimony for Senate Bill 826. We'll now turn it over to the committee for questions. And I see that Senator Jackson has his hand up. So Senator Jackson, you're up. I'm going to ask to unmute you here. There you go.
Thank you. I guess I appreciate the opportunity, Mr. Chair. Thank you for the presentation. I think Mr. Pennick answered one of my questions. I was wondering, looking at the committee testimony, I did not see the Maryland State Police. I did not see the Maryland Chiefs and Sheriffs Association. So I guess I got the answer on that, but I have a couple of questions. And I'll start with a statement. The correctional officers in the state of Maryland had the ability to actually get the wear and carry. That was taken care of a few years back. And so you all were talking about being able to carry off duty, correct? I mean, I'm not sure, how a firefighter would place a weapon on he or she, on a scene. Are you talking about on duty or are you talking about off duty? If someone could answer that before I proceed.
So, Senator, I can't speak for each member of.
Well, let me do this. Let me ask the maker of the bill if Senator Carrozza, is the intent of the bill to have them carry while on duty or while they're off duty to protect their families?
I would like to work that out with the committee. Obviously, they've already identified that it's an assumed risk, and I would like to give them as much protection as possible, but I think any type of additional protection would help them at this point.
Okay, well, sure. I would love to speak to you about that as well. I mean, if we're talking about fire and EMS, I think, okay,
And I guess my point would be, it doesn't, it would give them the opportunity to pursue that permit. It doesn't, obviously, I think, concerns about numbers, but it at least in the situations that have been described would give these individuals the opportunity to pursue this without, actually having to have experienced an attack or have the threat, since they would be under those assumed risk occupations.
Yeah, well, yeah. So, carrying a weapon on duty is pretty much part of the uniform of the service, but I certainly understand the off-duty piece, and we can certainly talk about that. Lastly, I would like to speak to the Ocean City folks, and I'll end on this, Mr. Chairman. Catherine Rick Koch is a neighbor of mine in another world. Say hello to him for me, and I look forward to working with the sponsor of the bill for further clarification from my perspective. I am not openly opposed to the off-duty carry. I do have an issue, for the record, with anyone other than part of your duties to carry a weapon while on duty. So we can certainly talk about that. Thank you, Mr. Chairman.
Excellent. Thank you, Senator Jackson. Okay, looking around the committee for additional questions. Seeing none, that will conclude the hearing for Senate Bill 826. Thank you very much, Senator Carrozza, and thank you to the panelists.
Thank you, Mr. Chair.
Thank you. All right, we'll go on. So we have, I know that Senator Reedy just popped in, but Senator Jackson, your witnesses have been in the room for a while. So I'm going to go to you just really quickly, and then we'll toggle over to Senator Reedy. So thank you very much, Senator Reedy. Our apologies, but thank you for being patient. Senator Jackson, the floor is yours for Senate Bill 918.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Jackson, Senator for District 27 on behalf of Senate Bill 918. Senate Bill 918 is a straightforward piece of legislation that simply changes from 3 years to 4 years the amount of time to institute the prosecution or to impose a civil fine relating to an election law offense. While the State Board of Elections is able to handle minor administrative election law violations, they require the assistance of the Office of the State Prosecutor for cases involving significant amount of complexity. I happen to have been a party to one of those myself early on in my legislative career, so I certainly understand. The State Board of Elections makes every attempt to protect those who unknowingly commit violations and allows them to bring their campaign finance accounts into compliance before prosecution. These efforts to bring a counselor to compliance, however, often last well over a year, putting the office of the state prosecutor at a severe disadvantage in investigating egregious violations and bringing forward potential charges. If enacted, the added amount of time that this legislation will provide would allow prosecutors to better complete the investigations. This would help them better to do their job, holding those accountable for intentionally and maliciously seeking to undermine the integrity of the campaign finance laws. I actually sponsored an identical bill, House Bill 627 last year, while a member of the House of Delegates. That bill passed unanimously on the House floor, but due to COVID, it did not make it to this chamber. I'm hopeful that this year circumstances will be different. There's nothing more important than ensuring the fairness of the electoral process and our election law. This is a good bill. It's a needed bill, and I think it's something that we can all get behind. With that, Mr. Chairman, I would ask you and the committee for a favorable report of this legislation. And with your permission, I'd like to bring in my panel of supporters, including Mr. Jared Demarinis of the State Board of Elections, and to answer any technical questions. And Mr. Demarinis also has a clarification amendment for us to discuss. Thank you, Mr. Chairman.
Excellent. Thank you, Senator Jackson. And so I have Mr. Demarinis as your primary witness, so he'll have 5 minutes. Jerry, good to see you.
Good
Been
seeing
too
you,
long.
Chair.
We'll catch up soon.
Yes, definitely.
Sure.
And I just wanted to say thank you, Senator Jackson, for introducing this bill again, this time as a senator. So he explained it quite eloquently for the need for the extra year because we work closely with the state prosecutor's office, and we take as much time to get the committees in compliance as possible before referring it over to the state prosecutor's office. That extra year will allow for increase in enforcement. Additionally, this extra year is bringing it to 4 years, makes it in line with the election cycle. So it's just almost a no-brainer and stuff. And it allows for greater investigations and detailed audits of non-compliant campaign finance entities by the State Board and the Office of the State Prosecutor's Office. Additionally, the legislation adds a civil enforcement authority to the statute, which is Election Law Article 13604.1. In 2013, the General Assembly added civil enforcement authority to the State Board. However, the corresponding provision was not added in the Court and Judicial Proceedings article. So this legislation corrects that oversight. The proposed amendment that the Senator mentioned clarifies the enforcement powers for the Office of the State Prosecutor to seek penalties against entities in violation of provisions in Title 14 of the Election Law Article. This Title 14 is the one that requires businesses that have state contracts or any sort of government contract to report their political giving activity basically semi-annually to the State Board of Elections. Just like you have reports that are due, they have it twice a year. And when we also amended it in 2013, the late fees were to be processed by the State Board in the same manner and method as a political committee under Title 13, which is what you're governed by. However, in Title 13, there is an express authority for the Office of the State Prosecutor to seek civil penalties and remedies for this. That provision is only inferred in Title 14. This proposed legislation and a proposed amendment clarifies that civil enforcement authority and assists in the referral of late filings of the Title 14 offenders. And we have, I know that the State Office of the State Prosecutor is both here to help support this legislation and proposed amendments as well. With that, I'm happy to answer any questions, and it's good to be finally in this committee. So yes, thank you.
Excellent. Thank you very much, Mr. Demarinis. Always good to see you. And next we'll have Ms. David. Ms. David, you were on.
If it's okay, Mr. Chairman, could Ms. Byrd go before me?
Of course, yes,
Thank
absolutely. Ms. Byrd, you're up.
Thank you. Thank you, Mr. Chairman, Mr. Vice Chairman, and members of the Judicial Proceedings Committee. My name is Lindsay Bird. I am the Senior Assistant State Prosecutor at the Office of the State Prosecutor. We are a statewide agency that is tasked with, among other things, investigating and prosecuting election law offenses. Our office has both civil and criminal enforcement power for most election law offenses. We reserve our criminal enforcement power for cases where it's clear that there's been a willing and knowing intent in violating the law. For other cases, we utilize our civil enforcement power. And the extended statute of limitations is an important and necessary tool for both of those mechanisms. With regard to civil enforcement, we recognize that campaign finance law is complicated and that people without legal backgrounds often serve as officers of campaign finance entities. And for that reason, when there's no evidence of a knowing and willful violation, we extend committees and officers time and assistance in coming into compliance, which of course is the ultimate goal. Unfortunately, not all entities or officers take advantage of that opportunity. And there are cases where we don't have evidence of criminal intent, but we do take enforcement action. And in those situations, we issue civil citations. An extended statute of limitation gives us the ability to both offer opportunities to come into compliance while preserving our ability to take enforcement action when it's necessary. With regard to criminal enforcement, the cases in which there's nefarious intent are the ones that, excuse me, are often the most difficult to discover. The secretive nature of these cases often make detection difficult and also make investigation time-consuming and resource-intensive. And we have encountered situations where we have ultimately uncovered criminal behavior, but have been unable to prosecute it due to the statute of limitations. If we're going to be able to completely and thoroughly investigate and ultimately prosecute election law offenses, we need the time to do it effectively and the time to capture the full spectrum of behavior. With regard to the amendment, as it relates to Title 14, that is a technical fix that our office needs to properly enforce that section, and my colleague, Ms. David, will elaborate on that in a minute. So for these reasons, we would ask for a favorable report from this committee on Senate Bill 918. Thank you very much for your time.
Excellent. Thank you, Ms. Bird. And Ms. David, you're up next. Just got off the phone with the former chair of JPR. He says hello, by the way. So you're up.
Well, great. Well, thank you, Mr. Chairman and Mr. Vice Chair and members of the Judicial Proceedings Committee. My name is Sarah David. I'm Deputy State Prosecutor for the Office of the State Prosecutor. Thank you so much to Senator Jackson for introducing and championing this very important legislation. Ms. Bird has rather thoroughly explained kind of the aspects, as well as Mr. Demarinis, of kind of extending the statute of limitations and why that's necessary to deal with truly kind of subversive behavior. Title 13 is probably an area of election law that the members of the committee are a little more familiar with, in that you've all run for office. And so you file those forms and kind of understand that area. I want to quickly just touch upon a little bit of what we're talking about in the amendment in Title 14, which mandates that business entities that have a single contract of at least $200,000 with a governmental entity file statements with the State Board of Elections, which list those applicable campaign contributions. This is an important thing to encourage transparency and seeks to avoid the corruption in the awarding of state contracts. Importantly, the fines that already exist. This technical amendment is here to ensure that the enforcement of those can be both civil and criminal. And with that, I'll yield to questions from the committee and hope for a favorable report on this legislation.
Thank you very much, Ms. David. And with that, that'll conclude the testimony for Senate Bill 918. We'll now turn to the committee for questions to see Senator West.
Yes, thank you, Mr. Chair. This is a really lawyerly observation more than a question. And that is, in the very beginning of the bill, under section 5106-H, or subpart H, there are brackets which completely delete the nature of the prosecution we're talking about. And as changed, it would really say a prosecution shall be instituted within the time period. The problem is section 5-106, it's a section of the Courts and Judicial Proceedings article, which contains numerous subparts, each one dealing with different sorts of prosecutions. So I'm just looking at them. C is a prosecution under the Vehicle Code, D, a prosecution for Sabbath breaking, F, prosecution for commission, et cetera, It goes on and on and on. Each of these subparts contains a specific prosecution. So in what I see in the bill here, the bracketed language, deleting that would not describe the prosecution we're talking about. So I would suggest the committee staff take a hard look at whether or not we ought to leave those brackets in or take them out. With that, I'm satisfied with the bill. Thank you.
All right, excellent. Thank you, Senator West. All right, turn to the rest of the committee for questions. Seeing none, that concludes the hearing for Senate Bill 918. Thank you very much, Senator Jackson, and thank you to all the panelists. It's good to see you all. All right, next we'll go on to Senator Reedy. Are you still here with us? Excellent. Senator Reedy, you're up with Senate Bill 760. Good to see you. You are unmuted, but we cannot hear you. We still can't hear you. Now you're, let me do this. There you
How
go.
about this?
There you go. We got it.
Sorry. Wow, that's very strange. Okay. Sorry about that. Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. It's great to be before you again today to present Senate Bill 760, dealing with animal cruelty and the cost of care for seized animals. This is an issue that we've dealt with before. The bill before you, we've submitted some significant amendments that have come as part of a discussion with a number of stakeholders, and the House has also acted on these amendments. So my testimony will be speaking to the bill as amended. Senate Bill 760 is a common sense bill that provides for affordable preservation of humane treatment of animals in Maryland. Cost of care animal legislation is smart and reasonable, and it puts the cost of caring for animals where it belongs, with the person who is responsible for the animal. This legislation establishes a legal process for individuals who've had their animals seized due to cruelty charges. It only requires the owner to pay for the cost of care if the court determines a seizure was lawful. One of the greatest obstacles, as I know many of you know from sitting through some of these hearings in the past, one of the greatest obstacles in enforcing animal cruelty laws is the large cost associated with caring for abused animals while cruelty charges are being prosecuted. And as you know, it's not so much about the one dog or one animal. It's when they're, particularly for smaller counties, when they seize a large number of animals, horses, those kind of things. So it's very, very debilitating costs to holding animals for a long period of time. So what Senate Bill 760 does is it prevents animal control agencies from incurring those costs, holds abusers accountable for their actions. At the hearing, the seizing agency must present evidence that demonstrates reasonable cost of care for the animal and that the seizure was warranted. It caps what an owner could be charged at no more than $15 per day, and that's the ceiling, plus necessary veterinary cost. And additionally, it protects owners by providing a legal process, allows them to challenge the legality of the seizure. If they are ultimately not found guilty in a criminal trial, they can have the bond repayment the bond they posted returned. Currently, the alleged violator may file a petition for the return of the animal within 10 days, or the animal will be considered forfeited. Under this bill, the county district court is required to hold a hearing within 21 days from the day the animals were seized. If the owner fails to post bond, ownership of the animal is relinquished and the seizing authority can adopt the animal out. And again, as I mentioned earlier, for major animal cruelty cases, whether it's dog fighting or seizure of dozens of animals in a poorly run farm, the cost of care for these animals can be months or years with cruelty charges pending. And it's devastating to particularly smaller and medium-sized county budgets. And I would imagine it's not, I don't believe it's helpful for any county's budget, no matter how large they are. Financially strapped centers can be forced to turn away adoptable animals due to limited resources. 36 other states have similar mechanisms in their law to shift the cost of caring for seized animals from county animal control to the owners. This is an essential bill to helping to protect the humane treatment of animals in our state, and I would urge a favorable report and look forward to our presenters.
Excellent. Thank you, Senator Reedy. So we have So I have Ms. Bevan Dangle as your primary witness, and she'll have 5 minutes. So you're up next. Good to see you.
Wonderful. Thank you, Mr. Chairman, members of the committee, and many thanks to our sponsor, Senator Reedy, Delegate Moon, for being willing to bring this bill back before you. My name is Jennifer Bevan Dangle. I'm the Maryland State Director for the Humane Society of the United States. And as one of the attorneys on the panel, I get to talk to you about what the bill does and what the amendments do. And my panelists who are following after me will talk a little bit more about why this bill is so critically needed. We do appreciate that in 2019, this committee moved a piece of legislation that we had hoped would address Maryland's failure to have a clear, consistent cost of animal care law on the books. Unfortunately, as amended, that legislation keeps the entire cost of care determination process at the end of all the other proceedings. So it's not until the end of the criminal case that these costs of care are determined. And as you'll hear from other witnesses, as a result, our shelters are not receiving the funding they need and deserve, and we've still not cleared up the underlying confusion that was pointed to in the 2017 Roar case over who technically has ownership of these animals throughout that proceeding. Maryland's failure to have a upfront, clear, consistent cost of care law is certainly going noticed. The American Bar Association has passed a resolution urging all states to pass some type of law to create clarity and sort of an equity for all the partners in this situation. And the Animal Legal Defense Fund ranks Maryland 31st out of 50 states. And largely that is due to our failure to have cost of care, because as this committee knows better than any other, we have worked incredibly hard to have strong laws to protect animals from cruelty in Maryland. The need for this bill, again, is around, as the senator said, these large hoarding cases, these intense abuse and neglect cases, where the shelters are being expected to put out significant funding up front for animals who have high vet bills and other needs. We were very grateful for the work of many, many stakeholders in spending time with us in advance of this hearing. We know that this committee is working harder than perhaps any other committee this session with your voting sessions and your work sessions. So we wanted to bring you a set of stakeholder amendments that would get the bill, as close as we could get it to being ready for prime time here. The 3 main things these amendments do. First, the bill as drafted was based on Pennsylvania law. Pennsylvania, our neighbor to the north, actually has a very strong cost of care law. However, we had to correct some drafting errors that would have changed other, underlying processes that are Maryland specific, because we were modeling off of another state jurisdictions. And the most important thing the amendments do there is clarifying that the current process, where it's the owner who requests the petition hearing, that burden stays on the owner to request that. That's one of the pieces of our law that's working, so we certainly didn't want to undermine or change that. Second major change, we were grateful for the conversations we were able to have with Maryland Horse Council, and certainly we heard concerns from Farm Bureau. The shelter partners agreed to exempt livestock from this version of the bill, and that really shows you how critically, desperately needed this cost of care legislation is, because our shelter partners are so keen to see an effective law on the books to deal with companion animals that we were willing to set aside that conversation around livestock and other, large expenses, because the need is so significant, especially this year where our shelters are dealing with so many other financial burdens related to COVID. The third set of sort of changes that the amendments do is we wanted to make sure we created very clear protections for owners. And thank you to many of you who met with us during our Humane Week of Action earlier in February. Thanks also to some other advocates and stakeholders who talked to us about their concerns. There are 3 significant changes with the amendments that we believe make sure that owners are protected all through the process. First, during this seizing hearing, the judge must find by a preponderance of the evidence that the seizure was warranted for any of this to come into play. So that judge has to look at the evidence provided by the shelter and say, yes, looking at this evidence, fairly high evidentiary bar, the seizure was warranted, so this whole thing will move forward. So that's a very strong evidentiary bar that protects owners up front at the start of all this process. The second is the bill creates clarity that in a small seizure case, the judge can consider the ability of an owner to pay the cost of care when they're setting the bond. Certainly Humane Society, our shelter partners, none of us want to see any owner lose their pet simply because of financial limitations. So that's an important protection to make sure that no owner is going to have to forfeit their pet simply because of the cost. And then lastly, as the senator mentioned, the costs are fully returned to owner if they're acquitted or found not guilty at the conclusion of the trial. So there's a protection at the front end and the back end for owners. And you will hear from our shelter partners just how critical this bill is to make sure that all the players, and especially the animals, are kept in the safest and healthiest manner as we look at these large seizure cases coming in. So we thank the committee for your consideration. We thank the senator, and we urge a favorable motion with the sponsor amendments.
Excellent. Thank you very much. We appreciate the a lot of the hard work that's gone into this ahead of time. So next we'll have Crankshaw Quimby. You're up next.
Thank you, Honorable Chairman Smith, Vice Chairman Walden-Stricker, and the entire committee. I am Patty Quimby, the Executive Director of Talbot Humane and Talbot County Animal Control. Today I'm before you as the President of Professional Animal Workers of Maryland. We are the state organization comprised of animal control and humane societies. We unanimously stand in support of SB 760. Animals are property in the state of Maryland. Unlike other items which, when they're seized, can be put into an impound locker or a impound lot, animals require that daily cost of care, and that often includes additional veterinary care, special feeding, and extra time. It's often months or at times over a year before these cases are heard. Even when restitution has been required at sentencing, we all too often are not seeing these fees paid. And the cost of care of these animals is landing in the laps of the taxpayers, not the custodians of the animals. We believe this bill definitely provides protections for both owners and agencies. You've heard it provides a clear process for determining ownership. We're still seeing animals sitting in limbo until the criminal case is concluded. The care of these animals remains on our laps. The hearing will be set within 21 days of seizure. And at that petition, once that petition is filed and the hearing is held, it requires our agencies to provide evidence that the seizure was reasonable, a reasonable cost of care, and allows that owner or custodian to object to the evidence. It also sets a clear process for owners and ownership at the throughout the entire process. This includes the cost of, if the cost of care is not paid, if the owner or custodian chooses to surrender the ownership of these animals at any given time, and if the owner is found guilty. It also allows for the return of the animals and or funding at the end if the owner is acquitted or charges end up not being filed. We also wish to make clear this bill refers to cases where violations of the Maryland Code have been allegedly committed, which rise to the level requiring seizure of animals. Violations of jurisdictional laws, such as animals running at large, which are picked up as stray, or other infractions have administrative remedies at the local level, which often include fines and fees. These are for those egregious cases. We had a case here in Maryland within the last few days. A shelter's taken in almost 40 exotic birds. Imagine the cost and time that's taking those shelter workers and what that's going to look like on their budget. The clarification in the state law is needed to protect owners, agencies, and animals. We ask for a favorable report. Thank you.
Next, who is the next advocate?
I believe that'd be me. Hi, my name is Devin Neal. I'm here representing the Maryland Association of Counties today to support Senate Bill 760. I've submitted written testimony, so I will keep this brief. This bill creates a reasonable process to hold those who have committed animal cruelty accountable, as well as recoup the costs that are incurred by local animal control agencies or shelters while caring for the animals, waiting for the trial to happen or before returning them. As has been mentioned previously, this can be very costly depending on the size and severity of the cases that we see, and can truly place a very expensive burden on our local animal control agencies, especially those counties and local animal control agencies from smaller jurisdictions. This builds upon previous legislation, but really outlines a clear and fair process to make sure that our local animal control agencies and shelters are not being burdened by these costs during this. And for that, Mako requests a favorable report on this bill, and I'm happy to answer any questions for the committee.
Yes, we'll go to our witnesses before we ask questions of our witnesses. Is Deborah, is Deborah there? Yeah.
Yes, I'm here.
Straight ahead. Thank you for appearing.
Good afternoon. My name is Deborah Rowe, and I'm the Director of Special Projects at BARCS, Baltimore Animal Rescue and Care Shelter. We're a nonprofit and largest companion animal shelter in the state of Maryland. We partner with Baltimore City Animal Control and care for all animals seized by animal control. We are financially responsible for all animals that animal control picks up from hoarding cases, cruelty cases, and animal control violations. This presents a financial burden that requires us to use resources that could be better used to help people and their animals in our community. In Baltimore City, not all judges order restitution. While some defendants are ordered to pay restitution by the courts, many do not pay. Since 2015, the courts have awarded $83,305.29 in restitution to be paid to parks.
Who spoke, Ray?
Of that, only $45,985 has been received. So $37,319 of cost of care was the unpaid balance. Many defendants are put on probation and told they must pay by the end of their probation. Many do not, and they are not held accountable. An example of a case that the Cost of Care Act would have been helpful is a seizure of over 60 snakes from a property. BARCS had to purchase proper containers to hold the snakes. Some of the snakes were sick and needed treatment, and food had to be supplied for the snakes. Many of these snakes were in our care for over 30 days. This bill would help BARCS by eliminating the financial burden that cruelty seizures, animal control violations, and hoarding cases are to the shelter. This bill does not affect stray animals that come into BARCS and are redeemed by their owners. The owners of stray animals pay a fee when redeeming their animals based on the care that they've received from our shelter. BARCS has observed that most owners of animals seized do not want their pets back or are not allowed to get them back due to the circumstances surrounding their case. However, BARCS must continue to hold and care for them at our cost. BARCS does not turn any animal away, so we must always be considering how to get animals into positive placements quickly. Many of the animals that BARCS is required to hold for court cases can be with us for weeks or longer. This results in stress on the animals being held and less space for other animals in need. BARCS strongly encourages you to pass this bill. While it may appear that this bill is only about the finances of the shelter, what it really means is that shelters like BARCS will be able to use this money to help more people in need from our communities with pet-related issues. Thank you for your time.
Thank you so much. Our next witness is Crystal Maury. You're up.
Yes. Hi, good afternoon, Chairman, Vice Chair, and members of the committee. My name is Crystal Maury. I'm the Field Service Director for the Humane Society of Washington County. I'd like to take my time to explain to you how the agencies supporting this bill actually operate to give you a clear sense of why it's so urgently needed. My agency, like excuse me, many others, is subcontracted by our local government to uphold county and state laws and are given a percentage of our operating budget. Last year, my agency's budget was $2.5 million. We were given 1.4 by the county towards our contract. The remaining deficit is up for us to find through fundraising and private donors. It's not easy, and like every other year, we are in the red. None of us are fully funded, yet we continue to take on animals that are victims of neglect and cruelty and spend sometimes thousands of dollars per case. An actual example of mine, I respond to a welfare check on a dog the callers claim are not feeding. I arrived to find the dog in emaciated condition, barely able to stand. Excuse me. The owners claim it just got that way, and they don't know why. The dog's then impounded and rushed to our local emergency vet, where the vets are on staff rushed to save its life. Blood work shows organ failure from dehydration and malnutrition. No other cause for its horrendous condition can be found through testing other than the owners not providing food and water. 48 hours later, $2,335, the dog is released back to our custody in guarded condition after it's stabilized. Now the long process of introducing food begins. The dog must be fed small amounts every 2 hours around the clock for the next 7 days. Our staff is in the building 12 hours a day. So now we must pay staff to come in every 2 hours all night long for 7 days. Say we've reached the $15 an hour minimum wage that's coming. We are paying staff to make 5 trips at night, totaling $75 a day just to feed the dog through the night. The emergency vet and staff wages are now at $2,760 in just 7 days. This does not include the prescription food, additional blood work, and continued vet monitoring. All this because the owner neglected their animal and did not reach out for the abundance of help that is offered in every community, such as food banks, or they could have surrendered it to a shelter if they couldn't care for it. This bill introduced will cover up to 15 a day. The judge can go lower, but just as I explained in some cases, it won't even come close to covering the expense. We are willing to settle because we need this help now. The owners must be required to pay for the damage they cause if they want to retain their ownership rights. All this evidence of neglect is what would be presented at this hearing. It's the same exact evidence that we presented at the criminal trial. The judge will have all the facts in front of them at this hearing. And yet there's still provisions in this bill that will guarantee the owner full reimbursement if found guilty at a criminal trial, which is highly unlikely. I ask that you give a favorable report to SB 760.
Thank you, Ms. Mowry. Thank you for your testimony. Now we will have the opposition. Charles Hall, please proceed.
Chair and Vice Chair and members of the Judicial Proceedings Committee, thank you for the opportunity to provide testimony to you today on Senate Bill 760. My name is Charlie Hall, and I am here today to represent the American Kennel Club, our Maryland affiliate dog clubs, and thousands of constituent dog owners in Maryland to express our concerns with the bill. First, I would like to thank the sponsor, Senator Justin Reedy, for taking the time to meet and personally discuss our concerns. Since I have also provided written testimony, I will limit my comments to our main concerns. The AKC strongly supports the humane treatment of dogs and believes that no dog or animal should be kept in cruel circumstances. We agree that those convicted of animal cruelty should be held accountable, including paying for the cost of caring for the animals they mistreated. However, AKC continues to be concerned that Senate Bill 760 will have detrimental effects on animal owners whose animals are unjustly seized or who are found not guilty or against whom charges are dismissed. We do appreciate that the cost for care is limited to a maximum of $15 per day per animal, plus the reasonable cost for veterinary care if needed. However, we are concerned that the bill can and likely will result in the loss of ownership of an animal that belongs to an owner who is ultimately found not guilty of the charges or has the charges against them dropped. While we do appreciate the amended language will require the seizure of an animal to be based on a preponderance of the evidence, the final determination of guilt or innocence on charges remains to be beyond a reasonable doubt. As such, Senate Bill 760, as we understand it, does not allow a person to be innocent until proven guilty, and disproportionately impacts those with low or fixed incomes who may not be able to pay the charges throughout an ongoing trial process. AKC believes that if the individual is not guilty, their animals should be returned to them and they should continue to be the owner of the animals. I request an unfavorable report on this legislation absent language that protects the ownership rights of an innocent owner. Thank you for hearing my testimony.
Thank you, Mr. Hall. Now we will entertain questions from our committee members. Committee members, are there any questions of our witnesses? Seeing none, that ends the hearing on SB 760. Thank you, Senator Reedy. Now we'll move on to SB 842. Senator Benson, please proceed.
Yes, thank you very much, Madam Chair. Good afternoon, and to the members of the Senate Judicial Proceedings Committee, Senate Bill 842, work group to study the assessment, treatment, and available resources for female youth in contact with the justice system. Establishes the work group to study the assessment, treatment, and available resources for female youth in contact with the justice system, to be staffed by the Department of Juvenile Services. Among other tasks, the work group must review existing programs, treatment, capabilities, and facilities for females committed to the supervision of DJS and how DJS is responding to the increase of female youth participating in violent delinquent acts. And I'm right there to tell you all that I have been reading information and studying the data relative to what's happening to our young people. And the thing that troubles me deeply is the fact that we are beginning to see a significant increase in the number of females that are being incarcerated. As a matter of fact, one of the reports that I looked at showed that we now have more of our young people, our young females, being incarcerated, going to prison than our males. And that, my friends, is so heart-wrenching. And we're talking about young adults here who are going to be, I don't want to get so upset about it, but it just does upset me, something terrible. This bill focuses on the needs of our female youth. It is important to look at all the factors that affect the female young youth in our judicial system. According to the National Juvenile Justice Network, most assessment tools and treatment models used with youth in the justice system were designed for use with male offenders and have not been adequately tested with females. We need to further assess the results for our girls within the justice system. Our goal with Senate Bill 842 is to study the female youth in contact with the justice system. We want this bill to serve as a pilot program for studying the females within the juvenile system. It is our hope that this program will be successful in Prince George's County, and I see our wonderful state's attorney who is here today to testify, then can later be used as a model for other counties to adopt. So we in Prince George's County are willing to look at this program and to begin it as a model, as a pilot for the state of Maryland. I support the delegation's amendment to add a member from the Department of Correctional Services to the work group. I also support the Maryland Association of Youth Service Bureaus to add a member of MAYSB. So that would be absolutely wonderful, because we really, ladies and gentlemen, wonderful friends, need to see what it is that is causing our young women to be incarcerated, but also what services are available through our juvenile system that's already in place in the great state of Maryland that can help our young people, particularly our young girls. So I respectfully urge that you all give this Senate Bill 842 a favorable report, and I thank you for your attention.
Thank you, Senator Benson, for that excellent testimony and for being a champion of girls and women, especially and particularly in the criminal justice system and fighting for equality. And now we will turn to our witness, our wonderful Prince George's County State's Attorney, Aisha Brayboy. Proceed ahead.
Thank you so much, Madam Chair. And it's wonderful to be with you all today. And I want to wish a early happy birthday to Senator Benson. I don't know if I'll be able to see you on your birthday, so I thought this is my opportunity. But this bill is so important as it recognizes really the importance of intervention, not only when individuals are in the justice system, but the important role that local government plays in ensuring that there are appropriate programs for young women and girls inside and outside of the justice system. And so what this bill is, it's a local Prince George's bill, but it does give us an opportunity to look at the programs that are currently available through the Department of Juvenile Services, the Department of Public Safety and Correctional Services, but also the services that are available locally through our county government, through our Park and Planning Commission, through our school system, as well as through our local nonprofits, because it's important that we take a holistic approach really to address issues and needs of young women and girls who are justice involved or who are at risk of being justice involved. And I think we all recognize that there is a lack of services, targeted services for this population. And as the senator mentioned, it's a growing issue. So not only does obviously DJS and corrections have a role, but quite frankly, local government and our local community has a role too. And this work group will bring us all together to really begin to plan out and strategize how we will address these populations here in Prince George's County. So we hope that you will support this bill. And thank you so much for your time, and I'm happy to answer any questions.
Thank you, State's Attorney Brayboy, for your excellent testimony. And our next witness is Kimberly Haven, but I will turn the gavel over to our wonderful chairman, Will Smith, at this time. Thank you.
Thanks, Senator Lee. Ms. Haven, you're up.
Ms. Haven is not logged in.
Okay, great. Then we'll have Ms. Park. You're up.
Thank you. I'm Liz Park. I'm here from the Maryland Association of Youth Service Bureaus. We would like to support and be an advocate for Senator Benson's bill. We agree with her that young girls need special treatment. They need specific treatment for women, for the trauma they may have experienced in their lives, for the special experiences they have. And so we support her efforts to look specifically at females. There are 5 youth service bureaus within Prince George's County, so we're pleased to know that she accepts our amendment to add a youth service bureau to her committee. The 5 youth service bureaus are part of local municipalities, and that goes right along with what Ms. Brayboy was saying in terms of local governments and their responsibilities to these young women, and to make sure we're taking care of them and helping them throughout their lives. I also want to point out, as I did in my testimony, that this particularly impacts young girls of color. When we look at the data from DJS, girls who enter the juvenile justice system, of the girls that enter, 30% of the complaints are youth of color. When we look at girls who are then confined to juvenile services, it jumps to 68% of those young women are youth of color. So we need to make sure we're helping these young women get the services they need and keep them out of the juvenile justice system, which is what youth service bureaus are mandated to do. We ask for a favorable report of this bill and look forward to working with Senator Benson on this effort.
Let me look at that folder for a moment.
All right, excellent. Thank you very much, Ms. Park. And with that, I think that concludes the testimony for Senate Bill 842. We'll now switch over to the committee for questions. All right, seeing none. Senator Benson, thank you very much. State's Attorney Brayboy, thank you. Always good to see you both. And Ms. Park, thank you. And with that, that'll conclude the hearing for Senate Bill 842. We'll now move on to Senator Quarterman with Senate Bill 867. Senator Quarterman, you're up.
Thank you, Mr. Chair, members of the Judicial Proceedings Committee. Again, for the record, Senator Paul Quarterman, District 2 of Washington County. Thank you for the opportunity to present Senate Bill 867 to you this afternoon. Police officers, firefighters, and other first responders put their lives on the line each and every day to help keep our communities safe. Unfortunately, many of our first responders have been the target of unprovoked attacks. In December of 2020, a Montgomery County police officer was punched in the face twice by a young man for no apparent reason other than his uniform. In August of 2023, Prince George's police officers were shot in an ambush-style attack when responding to a report of robbery. And in January of 2020, a video surfaced showing a Baltimore police officer being kicked by a group of people while he was arresting someone who spat in his face. These are just 3 examples from the past year or so of behavior shown to our first responders simply because of their profession. Senate Bill 867 prohibits a person with a certain motivation from willfully intimidating, harassing, or terrorizing another person, causing certain damage to property or another person, or causing death or serious bodily harm to another person based on their actual or perceived employment as a first responder. Our first responders are sworn to protect, serve, and assist our citizens. We must honor this commitment with legislation that supports the commitment they have made to our respective communities. And as such, we'd ask for a favorable report, and thank you for the opportunity to present Senate Bill 867. Thank you, Mr. Chair.
Excellent. Thank you, Senator Quarterman. We have as your primary witness, Ms. Carpenter. Ms. Carpenter, you as a primary, you've got 5 minutes.
Thank you. Good afternoon, Chairman Smith, Vice Chairman Wallstreicher, and distinguished members of this committee. I would like to also thank Senator Cotterman for allowing me to testify in support of Senate Bill 867, the hate crimes for law enforcement officers and first responders. I thank Senator Cotterman, for bringing such an important piece of legislation forward. My name is Sharice Carpenter, and I'm the first vice president of the Fraternal Order of Police for Prince George's County and the legislative chair for the state of Maryland, FOP. Over the last few years, there have been significant increase in violence perpetuated against members of the law enforcement community, motivated in whole or in part because a person is a law enforcement officer, a member of the law enforcement agency, or a member of public safety. As children, we are taught what hate looks like and what hate sounds like. Some of us have had the unfortunate experience to know what hate feels like. Prince George's County Police has had the unfortunate opportunity to experience hate recently on 2 significant occasions. The first incident occurred on March 13th, 2016, when hate was brought to the doors of our District 3 police station. 3 family members drove to the district station and opened fire on the station as officers and members of the community and civilian employees were inside conducting business. Our officers faced that hatred head on, and the events led to the untimely and unfortunate friendly fire death of our brother, Corporal Ja'Kai Colson. The most recent event occurred on January 21st, 2021, while members of the Prince George's County Police Department were investigating a homicide. 2 hours into that investigation, while inside the crime scene, one of the detectives heard noises coming from a back window of a rear bedroom. The detective approached the rear bedroom and identified himself as a police officer, at which time 2 suspects who were standing outside of the window began yelling anti-police slurs at him. Those individuals then produced a handgun and fired shots into the bedroom where the detective was standing. Thankfully, the round missed the detective, and he was able to alert officers in the area that the shots they heard were those of the suspect shooting at him. Officers immediately gave chase and were able to apprehend both suspects without incident and recover a weapon. Lastly, last summer during the protests in Baltimore City, the Fraternal Order of Police Lodge 3 was vandalized, causing thousands of dollars in damage, specifically to that organization's building because they have members who are law enforcement. Every day, men and women employed as law enforcement officers in the state of Maryland put on their uniform and their badge and go out into these communities with the goal and the mission to keep Maryland safe. These men and women know the perils of danger that lie ahead with any call for service and are trained and prepared to handle whatever may come. However, what these brave men and women are not prepared to handle is to be targeted because they wear the uniform, the badge, or drive a car that identifies them as a law enforcement officer. They're not prepared to have their homes vandalized with anti-police slurs spray painted on their garage doors, their vehicles, or other property. Adding law enforcement officers and first responders to the hate bill gives a bit of comfort to the officers and their families, knowing that their loved ones face the dangers they saw coming and those lurking in the darkness, ready to ambush them because they swore an oath to serve and protect with dignity, honor, and integrity as law enforcement officers. While a law against assaulting law enforcement officers already exists, the burden of proof for that law involves serious injury or a hospital stay and very rarely results in a conviction and offers no enhancement on the penalty imposed with the exception of the title of the charge and the fine, which offers no deterrent. Furthermore, we recognize the distinction of an assault on a police officer and an assault fueled by hate. This proposed legislation will go far to protect those of us behind the uniform from being targeted based solely upon our desire to keep you safe. That is why I encourage you to support the law enforcement and first responders by favorably voting for this bill. Thank you.
Excellent. Thank you very much. And next we'll have Smilman. Will, you're up.
Afternoon, Mr. Chair, Senator Cotterman. My name is Will Milam, and I am the first vice president of the Maryland Fraternal Order of Police. I am also the local president of the Fraternal Order of Police Lodge 112, the union that represents the Prince George's County Sheriff's Office. I am here today to stand in support of Senate Bill 867, which would provide a criminal statute for hate crimes committed against first responders. I have served 18 proud years as a Maryland police officer. And I cannot tell you how many times during those 18 years where I have personally encountered people who have attempted to intimidate, harass, or terrorize me for doing my job. On several occasions, I nearly lost my life at the hands of someone intent on hurting me just because of the job I do and the uniform I wear. I have been spit on, I've been physically assaulted, and I've been shot at, all because I chose to wear the uniform of my community and to work in this profession. Nationally, this year alone, 45 officers have been shot, 13 of those in ambush attacks, and 11 officers have died wearing the uniforms of their communities. Much has been made and many steps have been taken this legislative session to protect citizens from bad cops. Bills introduced ranging from changing use of force standards to the removal of due process rights for police officers have been put forth this session, all for the purpose of removing bad officers and adding protection for citizens against police misconduct. While that debate continues, citizens and police officers alike are left to ask the question, but what about the good cops? What about the vast majority of officers who run towards danger while others run away? What about the officers who have conducted their business with the highest of integrity and heroism? Simply put, when is the legislature going to add those same layers of protection for good cops? Many of the committee, members of the committee, today you have the opportunity to do just that. You have the opportunity to send a clear message to Maryland's police officers and to those we are sworn to protect. You can say to Maryland and the rest of the nation that the state cares about all of its citizens, including those who wear a police uniform. So I and the Fraternal Order of Police stand in support of this legislation.
So thank you, Mr. Malum. And next we'll turn to, so that completes the panel for the proponents. We'll now switch to the opposition panel. Meredith, you're up. Good to see you.
Again, one more after this one. So thank you, Mr. Chairman, members of the committee. For the record, Meredith Weisel with the Anti-Defamation League. We're here in opposition to Senate Bill 867. This bill is similar to another bill that you heard a few weeks ago, Senate Bill 99, that seeks to add first responders and law enforcement officers to the hate crime statute. Just as a reminder, ADL is not just a leading anti-hate organization, but we also are the largest non-governmental trainer of law enforcement. We do trainings for more than 14,000 officers a year across the country on hate crimes, bias, extremism, and terrorism. We're very proud of the connections that we have with law enforcement and the joint initiatives that we work directly with law enforcement. And we strongly support laws that do deter attacks against our first responders and law enforcement personnel. But hate crime laws are designed specifically to protect victims who are targeted based on their most precious and personal identity characteristic, things like race, religion, national origin, sexual orientation, gender identity, etc. Working in a profession is not a personal characteristic. It's not immutable, and adding first responders in any way to that seeks to muddy the laws. It's a vocation or employment. Adding that to the hate crimes laws, it risks confusing the purpose of hate crimes laws. It weakens the protections. As noted by one of the proponents, Maryland does actually have on the books in the criminal statutes and Maryland Criminal Code 3203, where it treats an assault against a law enforcement officer, and specifically the statute says a law enforcement officer engaged in the performance of duties, a parole, a probation agent, a firefighter, emergency medical technician, rescue squad, or other first responders. It treats it as an assault as a felony, not as a misdemeanor. So the laws are already there specifically for our law enforcement and for our first responders. It's not the same as a hate crime. So for these reasons, we urge an unfavorable report because crimes against police officers and emergency responders are already taken seriously, and adding them specifically to the hate crimes laws is going to be unnecessary and counterproductive. Thank you.
Excellent. Thank you, Ms. Weisel. Now that concludes the testimony for Senate Bill 867. 67. We'll now turn to the committee for questions, and I see that Senator Huff has a question.
Thank you very much, Mr. Chairman. Question for the ADL. Do you consider homelessness an immutable characteristic?
I am unmuted or whatever. So Maryland already does have homelessness. It's not something that we, ADL, has necessarily advocated for. There are other categories that we have advocated for. Whether or not homelessness is immutable or not, I think could certainly be debated, and whether that's a personal characteristic. It's not something that we were a part of when the law was put in place in Maryland. It's not something that we specifically usually discuss. So I can't really, speak because it already is part of the law, but it's also not the same. I would just say this: it's not the same as somebody chose to be homeless versus somebody can choose to be a law enforcement official. They can choose to be a nurse. They could choose a different profession. We're specifically talking about profession or a vocation, and I don't think you can put homelessness even in that category either.
All right, so, but you said we shouldn't do it unless it's immutable, but you didn't answer my question. Yes
I said a personal characteristic, and most of those personal characteristics are immutable.
So you think being homeless is an immutable characteristic?
That's not what I said. I said it wasn't when the law was put in place in Maryland, we didn't take a position specifically on homelessness.
I'm just curious because so you don't want to answer if you think it's immutable or not?
I think that homelessness is it can be considered a personal characteristic. So whether it's immutable or not is certainly a debate that we could discuss, but it's not something that we take a specific position on. There are several categories that have been tried to be added to the hate crimes laws. And this one specifically that we're talking about, you're talking about a vocation, you're talking about a profession, and that is not something that is a personal characteristic. Homelessness is something that, the legislature added many years ago, and it's not something that we took a specific position on. So I can't answer you whether or not it's immutable.
I guess my point being is that, and I think you got it, is that if we're only adding things that are immutable, and I'm not saying I'm for the bill or against the bill, but just to testify that we shouldn't add things that are not immutable when Maryland's law currently already has things immutable. And I would think that you all would not be in favor of a bill to remove homelessness, would you?
We'd have to take a look at the language. I can't answer that today.
Okay.
Okay, thank you, Senator Huff. We'll now go to Senator Bailey.
Thank you, Mr. Chairman. I have a question for Will Milam, if you can unmute.
Yes, sir.
Sir, you referenced some statistics about ambush attacks that were carried out against fellow officers across the country. I was familiar if you know of any other profession in the United States where people lay in wait and ambush people like this.
No, simply put, no, sir, I don't. I've been a police officer for, like I said, 18 proud years. I did not sign up to be intimidated, harassed, assaulted, or killed. And frankly, I think that all too often our society has a tendency to consider instances of violence toward police as a part of the job. Well, I'm here to tell you that it's not. Bad behavior towards cops and other first responders should never be normalized. It should be penalized. And so, no, I don't know of any other profession where that is the case. And just to, I don't want to get into a back and forth with anybody, but this is a characteristic for me. I've been doing this job my entire adult life. I eat, breathe, serving others. And so this is my life. This is who I am. And for the other 20,000 Maryland police officers, this is who they are too.
So I have just another follow-up about that. Actually, two more. One would be the fact that you know a lot of your colleagues that are actually married and have children. And based on this alarming trend across the country, I'm sure you see officers who are changing their tags and taking things like the blue line off their car, removing FOP plates, because the profession that you're in is much larger than just the officers. It affects the wives and the children. Is that correct?
That's absolutely right. We are at this point teaching, recruits in the police academy to take different routes home because we're afraid of ambush style attacks when we get off work. It's not popular anymore for my 7-year-old and 9-year-old to tell people that their daddy is a police officer. That has somehow turned into, a dangerous thing where, at one point in society, it was a profession that was praised, and certainly other first responders as well. So things are changed. They aren't the way they used to be.
So, Will, thank you. Thank you, Sharice. Thank you for your service. Thank you for the fact to stand up and bring your testimony forward. I think this is a very important issue, and thank you, Senator Quarterman, for bringing such an important issue to our committee.
Thank you, Senator Bailey. Looking around the room for additional questions. Seeing no, Senator Sidnor, you're up.
Thank you, and I apologize that I don't have my video camera on so you can all see me, but for some reason it's not acting right this afternoon. But I was looking at the senator's written testimony and just wanted to make certain that I was understanding. There was one of your sentences was referencing a January 2020 video with a Baltimore police officer being kicked by a group of people while he was arresting someone who spat in his face. And you're using that as, I guess, an example of hatred, I guess, that people have for law enforcement officers. Is this the, and I just want to make certain that I'm thinking of because there was an incident that happened in my district where there was a police officer that was on the ground, and it was condemned by the governor and a number of other people. But then when additional video footage came out, it told an entirely different story. And I just want to make certain, is this the video we're talking about? It happened
Senator, who would you like to answer that question?
Senator Quarterman.
Oh, you're good.
Thank you. Sorry about that. I was having some technical issues here as well. As far as the incident you're speaking of and the one we referenced, I'm not sure if they're the exact same one or not. I'd be happy to give you the source that we referenced from that we utilized in that testimony. And I can forward that over to you so you can compare those to see if it's the same incident or not.
Thank you. Thank you, Mr. Chair.
So thank you, Senator Sidnor. Thank you, Senator Quarterman. Looking around the Zoom room for further questions, seeing none, that will conclude the hearing for Senate Bill 867. Thank you, Senator Quarterman, and thank you to your panelists. We'll now move on to Senate Bill 776 with Senator Lee. Senator Lee, you're up.
Yeah, thank you, Mr. Chairman. This is SB 776. It expands an existing hearsay exception for more children and vulnerable adults under Section 11-304 of the Criminal Procedure Article. This current statute allows the state to admit statements made by children under the age of 13 that relate to child physical and sexual abuse when those statements are made to certain individuals, including physicians, social workers, teachers, and therapists. The proposed law extends the exception to child victims of neglect as well. That is neglect of a minor under a criminal law article section 3-602.1 and crimes of violence as defined in our current public safety article 5-101 and crimes of violence. It also extends the hearsay exception to vulnerable adult victims of abuse or neglect in the vulnerable adult in the first and second degree of Criminal Law, Article 3-604 and 3-605. Another provision of the bill will extend the hearsay exception to children and vulnerable adult witnesses to crimes of violence that face similar intimidation factors. Under our current law, 11-304 has a specific scheme to omit certain out-of-court statements. The state must first notify, of course, the defendant of their intent to introduce a statement at trial, and the defendant is then entitled to depose the statement taker. The court then holds a pretrial hearing to determine if both of the statement is trustworthy and the child is competent to testify. At trial, the child has to testify and be subject to cross-examination. The statement taker then testifies and the state offers the child's out-of-court statement as substantive evidence. I believe that 11-304 exceptions should be applicable to statements made by victims of also child neglect and crimes of violence and vulnerable adult victims, as well as certain witnesses to those serious crimes. These victims and witnesses often have similar relationships to their perpetrators and face similar challenges when it comes to testifying, including their ability to recall specific events and their susceptibility to intimidation. A witness or a victim's memory of an event is much stronger, closer in time to the precipitating event, which is when most of the statements admissible under 11-304 are disclosed. Cases of this nature often involve very complex family dynamics that may over time result in a child or vulnerable adult becoming very reluctant to speak about the abuse that they experienced or witnessed, trivializing the nature of the abuse and even recanting their allegations altogether. A child or vulnerable adult's out-of-court statement made close in time to the event in a safe, a comfortable environment out of the presence of the perpetrator and before being subjected to the pressures of other family members may be reliable, more reliable than his or her testimony at trial. And expanding 11-304 to include child and vulnerable adult victims and witnesses to certain crimes will allow a judge or jury to hear a full and reliable account of what actually happened to the victim and what a witness saw. The rigorous trustworthiness tests in place with the right to confront the witness provide due process protection for the defendants while allowing this evidence to be brought forward in a very credible manner. The statement taker is also able to be cross-examined at trial, and the process is more reliable, more complete, and it unearths more important details for all sides to consider. For these reasons, I respectfully ask my esteemed colleagues to vote favorably on SB 776. I'll now turn it over to my panel of witnesses. I think Debbie Feinstein is the first witness.
That's right. Yes, Senator Lee, Ms. Feinstein, your primary witness. You'll have 5 minutes. Good to see you.
Nice to see you as well. Good afternoon, Chair Smith, Vice Chair Waldstreicher, as well as members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. My division is responsible for the prosecution of domestic violence, sexual assault, human trafficking, elder abuse, and other crimes against what you would expect in the category of special victims. I'm here today in support of SB 776 to expand the types of crimes and the individuals that can qualify under the tender years hearsay exception 11-304 that's articulated and delineated in criminal procedure article. I want to start with a couple of examples to really highlight the need to expand 11-304. Senator Lee really described what 11-304 is and how it's utilized. But let me give you a couple of examples. I've prosecuted child abuse cases for many, many years. I've been in the state's attorney's office for almost 21 years and spent most of my time, again, doing domestic violence and child abuse cases. In child abuse cases, children are often interviewed by a forensic interviewer or make statements to medical professionals. Those statements are then are typically recorded either audio or video, or are taken in notes. And if one of those qualified individuals takes those notes, records those statements, they may then be able to testify as to that statement as if the child is under the age of 13. Right now, the law only applies to child victims of child abuse, so sexual or physical abuse under the age of 13. This has been a really important tool in terms of giving access to justice for children in child abuse cases, because oftentimes, as Senator Lee described, a child who's giving a statement in a safe environment to a trusted adult away from their abuser at close in time, either to the time of the disclosure or to the time of the offense, that statement is determined and actually is inherently reliable under the case law in Maryland. And this law has been tested in the Court of Appeals. There was a case in 2008 that tested this statute and its reliability as well as its constitutionality. So what we're asking now is to expand that type of evidence, not just for a child abuse victim under the age of 13, but also for a child under the age of 13 who is a witness to child abuse, children who are under 13 who are victims or witnesses of child neglect, victims under the age or witnesses under the age of 13 that are witnesses to crimes of violence as defined under the public safety article. We specifically asked for crimes of violence to be defined under this public safety article to include second-degree assault. There are many occasions where a child witnesses domestic violence. They make a statement close in time to a forensic interviewer, or again to another trusted adult about what happened in their home on that date. Oftentimes, by the time we get to trial, that child may have been subjected to multiple influences, and or maybe in the presence of the abuser during the course of the trial. So the statement that they initially make when they're free from those influences, close in time, when their memory is the best, really become the most reliable information. So that would be for domestic violence cases. If they were a witness to a homicide, it would be included, a witness to a sexual offense, and that sort of thing. We also included vulnerable adult witnesses and victims for the same reasons that children under the age of 13 are included. Individuals who have cognitive limitations or differing abilities and significant mental health limitations really fall into the same category in terms of the reasons behind 11304. I can give you an example of a case that we had in Montgomery County where we had a vulnerable adult with intellectual and physical disabilities that was sexually abused by his mother. He made a statement to a reliable source in the beginning, to a forensic interviewer, right when the disclosure was made, shortly after his mother had sexually assaulted him. And in that case, that statement really became the most reliable in terms of what actually happened to him before he was subjected to his mother's influences, before he had to come into a courtroom full of strangers to be able to testify. That's exactly the kind of case that we're looking to apply 11304 to. Another example in the child neglect world is a case that we tried in 2017, where the defendant was accused of abandoning her 9 children, all under the age of 12, for 2 days in the middle of winter in their family van. She had severely emotionally abused her kids in addition. And at the time that they initially disclosed, it was in a safe, child-friendly environment away from their mother, and gave a full account of what happened to them. Being able to use those statements in court later, again, is an essential tool for prosecutors to be able to have those children get full access to justice. And that's exactly what this bill proposes, is giving full access to justice for children like these 9 victims of their mother's child neglect, like our victim of vulnerable adult sexual assault. That's the purpose of 11304. The right to confrontation is still satisfied because all of these victims and witnesses would still have to testify in the trial. This is not a substitution for their live testimony at trial. So the defense attorney would be able to cross-examine that child, would be able to cross-examine that vulnerable adult during the course of the trial. In addition, the defense attorney would have the opportunity to take the deposition of the statement taker, and that would be part of the reliability assessment that the court would have to determine. So for example, the forensic interviewer, in a moment, you're going to hear from Sarah Kulo Malave, who's going to discuss her role as a forensic interviewer, but she's often subjected to deposition to talk about the reliability factors, to talk about how the interview happened with the child victim of child sexual or physical abuse prior to that testimony even being considered by the finder of fact, by the court. So there are a lot of layers built into 11304 to assure that trustworthiness. And it's cases like those that I've described that really need this exception in order to, as I've described, give full access to justice for these victims. I would urge a favorable report on SB 776, and I stand ready to answer any questions. Thank you so much for your time, and thank you again to Senator Lee for sponsoring this important bill.
And thank you very much. And with that, we'll move on to Ms. Martz.
Thank you, Chairman Smith and Vice Chair and distinguished members of the Judicial Proceedings Committee. My name is Lisa Heil-Martz, and I'm here today to voice the Attorney General's Office support of Senate Bill 776. I currently serve as the Deputy Director of the Medicaid Fraud Unit, Control Unit, and this unit, which also prosecutes Medicaid healthcare fraud, is also tasked with prosecuting cases of abuse and neglect of elderly and vulnerable adults in the state. I came to this unit almost 2 years ago with over 20 years plus of experience as a local assistant state's attorney. And much of my time as a prosecutor was trying cases of abuse and neglect of children. I served on the Maryland State Council on Child Abuse and Neglect, have received several awards for my work with children and in child abuse and prevention efforts. But during my years of child work, I was very active in utilizing criminal procedure 11304, and I used it successfully many times. It's a very effective tool for child abuse prosecutors throughout the state, and it strengthens our cases against abusers and helps bring justice for the victims. Maryland's Medicaid Fraud Control Unit will greatly benefit from this new bill, as it will extend that same protection to our most vulnerable adults and the elderly in nursing homes and in group homes. It should be noted that it still requires that the victim testify at trial, thus not violating the Confrontation Clause. And it would allow, though, however, the trusted caretakers of this growing vulnerable adult population, the doctors, the nurses, et cetera, to testify as to the victim's statements about their alleged abuse. It would prove to be an invaluable tool that would enable prosecutors throughout the state to provide the courts and the juries a better and clearer picture of the abuse that the vulnerable victims, these adult victims, suffer. There are 11 factors that they would go through in the statute to guarantee the trustworthiness. There would also have to be corroborating evidence. And I would point out that many other states in the country already have these types of statutes for vulnerable adults. I made a career dedicated to serving and protecting the most vulnerable in our society, the children, the elderly, and the disabled. And I feel it's my duty as a public servant to speak up for those that struggle to speak for themselves. And I'm sure you would agree, both as public servants yourselves, that there is no greater honor to do that. And so for the foregoing reasons, the Office of the Attorney General would urge a favorable report on Senate Bill 776. Thank you.
Okay, good. So she's covering the vulnerable adults. So yes, okay.
All right, there we go. Grab her. All right, thank you very much, Ms. Martz. And that's going to move on to Mr. Schellenberger.
Chairman Smith, good to see you. Vice Chair Waldstreicher, glad the attorneys didn't talk too much at your last meeting. Members of the committee, I'm here in support of Senate Bill 776. Way back in the 1980s, this legislature was really ahead of the curve and ahead of their time when you passed a statute that basically adopted the common law version of what's called the tender years exception to the hearsay rule. And 11304 has been tested over the years in all the appellate courts and has been upheld as constitutional. And that would be as recently as State versus Snowden, and also a more recent juvenile case. And what we're doing here today is we're saying, take this statute that's been working for decades for the youngest and most vulnerable people, and let's turn around and now protect the oldest and most vulnerable people. And let's not ignore some of those child abuse victims who maybe don't suffer, physical or sexual child abuse, but neglect. So all we're doing is we're taking a great statutory scheme that has lots of protections in it, making sure that, the Confrontation Clause is not violated, but allowing us to use the hearsay exception in the statute to bring in the evidence that was gathered recently after the event occurred. And we all know, as Ms. Feinstein indicate, I thought it was a very good point, that is, once they make the report, there's very often that they're getting exposed to the abuser or the abuser's mom and dad, their grandparents. And the same with vulnerable adults. You know, they might have told the therapist or social worker what happened to them, but then there might be exposure to people who care about them, who try to change the story. And the story that usually comes out first with the individuals, like a therapist, like a doctor, or in the case of a child, like a principal or a teacher, the story that comes out first is usually the most complete. And that's why we believe we should extend this not only to child abuse victims in which neglect is there, but also expand it into vulnerable adults. In Baltimore County, 1 in 4 residents right now is in the aging class population. I don't want to say the age because I am getting, well, I'm kind of there already. So I won't say how old it is, but 1 in 4 adults in Baltimore County would be considered elderly and would be protected by this statute. And since that's expanding, it's time to expand the statute. I urge a favorable report.
Thank you very much, Mr. Schellenberger. And next we'll move on to our final panelist, Ms. Malav. You are up.
Thank you. Can everybody hear okay?
We can.
Okay, thank you. Good afternoon. My name is Sarah Kula Malave. Excuse me, I'm a clinical social worker and I am also the dedicated forensic interviewer at the Treehouse Child Advocacy Center for Montgomery County. I've been in this position for 8 years and conducted well over 2,000 interviews. Prior to that, I conducted child abuse and neglect investigations for Montgomery County for about 10 years. And that also included conducting interviews of alleged victims. I'm here in support of Senate Bill 776, which aims to expand the hearsay exception. I won't repeat, I know others have already described it, but in my role as a forensic interviewer, I frequently provide testimony regarding statements made to me by alleged victims of child sexual abuse. However, forensic interviews are not limited to victims of sexual abuse. I've also interviewed child witnesses to violent crimes, such as a 9-year-old girl who returned home from school one day to discover her father laying in a pool of blood. I also interviewed her older brother who's on the autism spectrum and happened to be home at the time of the murder. I have also interviewed a group of siblings whose mother was murdered in her bedroom while they were in their room, which was directly adjacent to their mother's. So these are the other types of interviews that I do conduct. I've also interviewed some vulnerable adults, including a young lady in her 20s who was wheelchair bound and was sexually assaulted while using Metro Access. And the statements made by these victims are equally as important as the statements made to me by victims of child physical abuse and sexual abuse. And as a forensic interviewer and a clinical social worker, I'm trained to ask as many open-ended questions as possible in an interview and to avoid suggestive or leading questions. Forensic interviews also include instructions to the interviewee, the child or the vulnerable adult, to correct me at any time when we're talking if I make a mistake or I repeat something incorrectly, and to always answer any questions to which they do not have an answer, to just say, I don't know, not to make something up or not to guess. The forensic interview always stresses the importance of talking only about something that actually happened. Thus, I'm able to gather more reliable and trustworthy information. The current statute already allows for me to testify regarding statements made by a child under 13 while I'm performing my duties as a social worker. I'm also a neutral party in the case. I'm not involved in determining the outcome of whether or not abuse or neglect did occur or if a crime was committed. My focus is gathering on information from an alleged victim or witness so that law enforcement and child welfare services can make decisions about safety. As Ms. Feinstein stated, my videos are all recorded, and I believe that by broadening the scope of 11304, the voices of all of our vulnerable citizens can be heard, and therefore I would urge the committee to issue a favorable report, and I thank you for your time.
Thank you, Ms. Malave. And with that, I believe that concludes the testimony for Senate Bill 776. We'll now turn to the committee for questions. Seeing none, that will conclude the hearing for Senate Bill 776. Thank you all very much. Thank you, Senator Lee. Great afternoon. Enjoy that weather. All right. Next, we will go to Senator Hettleman, Senate Bill 864. Senator Hettleman, you're up.
Thank you very much, Mr. Chairman. I'm happy to be here today to present on Senate Bill 864. Our country faces constant threats from abroad as well as from our own fellow Americans. Much of national attention, certainly since September 11th, 2001, has focused on international terrorism, and many resources have focused on keeping Americans safe from those from abroad who threaten to do us harm. But there are also significant threats that are closer to home. We need only recall that 2 months ago, on January 6th, Maryland's assistance was requested by our federal representatives to stave off a threat to our democracy and what has always been a peaceful transfer of power. Homegrown threats are not new. In fact, Americans today are more likely to suffer a terrorist attack by an American to suffer an attack by a foreigner. And last January of 2020, the FBI arrested 3 men, 2 from Maryland, who belonged to a white supremacist group called the Base. These men were in possession of a machine gun and accused of planning a mass attack in Richmond, Virginia during an upcoming rally. The New Jersey Office of Homeland Security and Preparedness 2020 Terrorism Threat Assessment Report states, quote, some white supremacist extremists argue that participating in mass attacks or creating other forms of chaos will accelerate the imminent and necessary collapse of society in order to build a racially pure nation. Senate Bill 864 would establish a task force on preventing and countering domestic terrorism, which would study and make recommendations regarding policies and procedures for preventing and countering domestic terrorism. The task force would examine the role of the state, the degree of expenditure of any resources, ensuring transparency with the public, the methods of funding, oversight and procedures, and strategies to combat online and other forms of extremism, with special consideration of First Amendment rights. Finally, it would report its findings and recommendations, including legislative and budget appropriation suggestions, to the governor and the General Assembly on or before December 30th, 2021. We cannot let what happened in Michigan or what happened in Washington, D.C. ever happen again. Pulling together the best minds and professionals who work on these issues with policymakers and stakeholders who can make recommendations to the General Assembly and the governor is entirely appropriate and within our responsibility to ensure that we are prepared and equipped to address these critical issues. And I'm happy to share with the committee actually a letter that was sent to the President of the Senate and the Speaker of the House and the Attorney General from the interim mayor of the city of Hyattsville, who actually is calling upon us to do just what I suggested and to make recommendations. So without further ado, I will turn it over to my panel, and I thank you very much for the opportunity to present the bill.
Thank you very much, Senator Hettleman. Have Mr. Braniff is your primary. And so as a primary, you'll have 5 minutes. Welcome.
Thank you so much, esteemed members of the Judicial Proceedings Committee. Thank you for having me. My name is William Braniff, and I'm the director of a terrorism research center that's based at the University of Maryland, College Park. It's called START, and I strongly support Senate Bill 864. Why do I support the bill? Well, START data demonstrates that other than the highly anomalous attack of 9/11, domestic terrorists, and specifically those espousing white power ideologies, are the most active, the most lethal, and the most numerous perpetrators of terrorism in the United States, both historically and currently. By percentage, START data demonstrates that violent domestic terrorist plots are also nearly 3 times as likely to succeed in killing or injuring someone than violent plots by individuals associated with or inspired by foreign terrorist organizations. And this is due to legal, political, and resource constraints that have historically limited the disruption of domestic terrorism. Furthermore, conservative estimates suggest that there are between 8,000 and 9,000 hate crimes per year in this country, compared to 60 to 70 terrorist attacks. And according to START data, nearly 90% of hate crime perpetrators are motivated by the same ideologies and social networks that motivate the plurality of acts of domestic terrorism, namely white power related ideologies. So given the relative lack of focus on this relatively more significant threat, I support this bill, but respectfully offer a few recommendations for consideration. First, I strongly recommend the inclusion of representatives from the educational system, the social work community, the mental health community in the task force. Research suggests taking a public health approach to violence prevention as a recommended way to deal with the issue of domestic violent extremism. And that public health approach requires a broader multidisciplinary task force. Second, the National Governors Association has created a set of research-based resources called the Governor's Roadmap to Preventing Targeted Violence. I recommend that the task force engage with these really useful resources. And significantly, the National Governors Association will be accepting applications from states to go through a free facilitated process to help support the creation of violence prevention efforts. Third, I also recommend that an academic expert with a background on these issues participate in the task force to help bolster the task force with an empirical basis for decision-making in this fraught and politicized arena. Finally, regarding the scope of the bill, I would recommend replacing domestic terrorism with domestic violent extremism, allowing the task force to address the spectrum of ideologically motivated violent extremism, including hate crime. Thank you for your time and your efforts to protect Americans against domestic violent extremism. Thank you.
Thank you very much. Next, we'll go on to Ms. Wiesel. Meredith, you're up.
All right, thank you, Mr. Chairman, Vice Chair. First, thank you to Senator Hedelman for introducing this bill. For ADL, we are here to support Senate Bill 864. It's important to note that not only does ADL work on legislation related to hate crimes, but one of the things that ADL has for a long time to fight bigotry and anti-Semitism and other forms of hate is also investigating extremist threats across the ideological spectrum. We work closely with our law enforcement partners, our educators, the tech industry, our elected leaders to promote some of the best practices to effectively address counter threats to the community. Violent extremists must be taken at their word, and volatile rhetoric online does bleed into explicit calls for violence, does bleed into real life. And what we saw at the nation's capital was one of the most horrific attacks on this country. It's also not the first time. We saw this happen in many state capitals last year leading up to it. It was one of the most predictable attacks on the US Capitol that we could have ever seen. The first step for us is to acknowledge the magnitude of the problem. The second is for federal and state governments to embrace new approaches and ways to prevent and counter domestic extremism and domestic terrorism. And this bill is the start. It creates a task force, and creating the task force is one of the first places that we can start. It's also important to note that when we're talking about violent extremism, and I appreciate William saying that before, because when we're talking about a lot of white supremacy. And white supremacy is mostly from the youth-oriented and overwhelmingly male alt-right. Most of the violent crime that we see and the most serious problems are coming from the white supremacist movement. Over the past 4 years, 2016 to 2019, white supremacists alone killed 116 people in the United States. They were responsible for terrorist attacks, hate crimes, and other violent acts. You can't legislate everything, and we can't arrest our way to a healthier society, but it's important to note that the fundamental cause of bias-motivated violence in the US is the persistence of racism, anti-Muslim bigotry, anti-LGBTQ, anti-Semitism, all the other biases. A few other suggestions also that we have for the task force. We are very heartened to see that it includes civil rights organizations as part of it. We would also ask that, and it has multiple representatives of law enforcement, we would ask that it also includes somebody from the public defenders or from the public defense bar. It's necessary that the recommendations of the task force are equitable and take into considerations of the civil rights communities. We fully support this bill. We actually also helped advise the National Governors Association report that was put out. ADL has that, and I included in my testimony something that we are calling our Protect Initiative, that if you have specific questions on it, it gives some guidelines as well for once the task force starts getting developed and ways for they can do it. So with that, we urge a favorable report of SB 864.
Excellent. Thank you very much. And next we'll have Mr. Peterson. Matt, good to see you.
Hey, good to see you as well. Thank you, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Matt Peterson, here on behalf of the Baltimore Jewish Council in support of SB 864. we heard just a few weeks ago from FBI Director Chris Wray testifying in front of the U.S. Senate, and he said that domestic terrorism is one of the biggest problems that the FBI is facing, and it is metastasizing at an exponential rate. And what we saw on January 6th in Washington, D.C. is just a symptom of a larger problem that our country is facing. Domestic terror groups are rapidly spreading, mostly due to the use of digital platforms that are constantly emerging. They're becoming more difficult to track and are becoming more undetected by the day. So the number of incidents that we're seeing are growing at an alarming and disturbing rate. And it's becoming a problem for our state, obviously. And we need to make sure that we're addressing this issue correctly, however we do address it. This work group will bring together some of the brightest and most experienced folks in this field to look at how we can take on hate, how we can take on domestic terrorism. Because like Meredith said, we can't arrest our way out of this problem. We have to be addressing it before it becomes a problem. At the Baltimore Jewish Council, we believe that the best tools we have to combat hate are education and understanding. We need to create a more cooperative environment here in Maryland, and we need to make sure that however we do address domestic terrorism, we're doing it in a correct way that really does go after the root of the issue. So with this in mind, I ask for a favorable report on Senate Bill 864. I want to thank you for your time, and I want to thank Senator Hedelman for sponsoring this bill. Thank you, and I'll be happy to answer any questions.
Excellent. Thank you, Mr. Peterson. We'll now move on to Reverend Kobe Little. Mr. Little, you are up.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. I'm Reverend Kobe Little. I'm here on behalf of the Maryland State Conference of the NAACP. We urge a favorable report on Senate Bill 864 with specific amendments. Let me first start by saying that the NAACP was founded specifically to respond to domestic terrorism, to the lynchings of African Americans that took place across the United States at the end of the 19th century and at the beginning of the 20th century. We would like to see the following amendments to the bill, where the bill suggests that there would be 2 civil rights organizations represented. We're fine with that, and we're fine if you expand the number of organizations or if you keep it at 2. But we're asking Senator Hedelman, you would amend this bill to specifically name the NAACP, which is the state's longest existing organization dedicated to fighting domestic terrorism. So that's the first thing. The second thing is that the task force is given 6 charges in the legislation, and we would suggest 2 additional charges. The 7th charge should be to eliminate safe harbor for domestic terrorists in law enforcement and other agencies of government. As it stands now, you've already heard testimony about the connection between domestic terrorism and January 6th. Too many of the members of that cabal that participated in the insurrection were also members of law enforcement or representative of other government agencies, not the least of which was someone who was an actual presidential appointee and currently contemporaneously employed by the State Department and on the State Department clock at the time in which he overran the United States Capitol. I can't stress to you enough how important it is for the Maryland state government to weed out domestic terrorists and their sympathizers in law enforcement and other agencies of government at the state and local level. And then the 8th point would be considerations for targets and victims of domestic terrorism. And so as I close, I would encourage that as this legislation is considered and passed into law, that there would also be an equity component of the work of this task force. Thank you again, Senator Hedelman, for your leadership on this issue, and thank you to the members of this committee for your consideration of my comments.
Excellent. Thank you, Reverend Little. All right, we will now move on to Mr. Grimes.
Thank you, Chair Smith, Senator Waldstreicher, and members of Judicial Proceedings, and thank you for your favorable reading yesterday on the Juvenile Restoration Act. I'm Seth Grimes, speaking on behalf of Tacoma Park Mobilization, which is an advocacy organization with a network of over 2,600 Marylanders. We oppose SB 864. We find the bill alarming with chilling implications for Maryland immigrants and people of color. The bill
Mr. Grimes, sorry, it's muted. Let me ask you to unmute you one more time. Here we go.
I'm sorry, how much did you hear?
We heard about the first 15 seconds.
Okay, I'm gonna thank you again for the Juvenile Restoration Act. I'm representing Tacoma Park Mobilization. We oppose SB 864. We find chilling implications for Maryland immigrants and people of color. The bill talks about promoting inclusiveness and celebrating diversity. This protestation is in there because the sponsors surely understand that these efforts often mistarget marginalized and dissenting neighbors rather than white supremacists. I bet that anti-immigrant forces in Maryland would seek to add MS-13 to the task force agenda. In fact, our own Maryland experience suggests that this bill will be mistargeted. I quote a 2008 article. Maryland officials now concede that state police wrongly listed at least 53 Americans as terrorists in a criminal investigations database. Maybe some of you know current Maryland Sierra Club Executive Director Josh Tolkien. He was called a terrorist environmental extremist. One of your Judicial Proceedings former members, Jamie Raskin, was included. He was surveyed, guilty only of meeting with his constituents whom Maryland State Police deemed suspect. This bill is alarming. In fact, the proponents have cited only national
I think I'm muted again. There you go. All right,
can you fix the time?
You're heading into the national scene.
I'm sorry. I'm sorry about that. Yes, the proponents have talked about the Capitol attack. They've talked about Michigan, where heavily armed white supremacist militias run rampant. This is not a Maryland problem. They have not demonstrated that this is a Maryland issue. Further, we find the mandate to be problematic. The House sponsor, Delegate Rosenberg, noted that there is no definition of domestic terrorism here. This could go anywhere. In fact, there is a discussion of oversight measures that is incredibly nonspecific and talk about finding ways to counter and prosecute online extremism. Given how borderless the online world is this really a Maryland issue here? So in summary, Tacoma Park Mobilization urges a unfavorable reading on SB 864. Thank you.
Okay, excellent. All right, next we will move on to Ms. Udry. Sue, you're up.
Thank you. Hi, everyone. I'm testifying today on behalf of the Silver Spring Justice Coalition, SSJC. We're a coalition of individuals, of course, a helicopter is flying by now, a coalition of individuals and organizations from Montgomery County, including faith groups, civil rights, and human rights groups. I also represent Defending Rights and Dissent, a national civil liberties organization with over 1,000 supporters in Maryland, and which is a member of SSJC. We appreciate the goal of fighting violent white supremacy, but we oppose SB 864. SSJC has submitted written testimony to the committee, which is brief, and I hope you'll take the time to consider it. We're extremely concerned about this bill, considering that just over a week ago on the floor of the Senate, Senator Ferguson purposefully conflated two events, receiving a threatening letter and a peaceful protest organized by SSJC. He labeled our peaceful car caravan an act of, quote, intimidation. In addition to the points made in our written testimony, I'd like to remind the committee that the history of the United States is replete with examples of policymakers and police using the threat of terrorism or extremism to silence dissent and harass and criminalize minority communities. From the House Un-American Activities Committee to COINTELPRO to the Patriot Act, Policies sold as necessary tools to protect us quickly turn into tools of mass violation of civil and human rights. As Seth noted, Maryland has its own recent history of police abusing their authorities to violate the rights of peaceful protesters. In 2005 to 2006, the state police spent 14 months infiltrating Baltimore Pledge of Resistance, the Maryland Coalition Against the Death Penalty, and other peaceful groups. The names of activists, including, for example, my friend Max Obashevsky, is a longtime peace activist and an avowed pacifist, yet his name was entered into the database describing his crime as terrorism, anti-government, and terrorism, anti-war protesters. There was never any evidence of criminal activity, yet the spying continued for 14 months. And although the whereas clauses suggest that the bill sponsors hope to avoid repeating this history, nothing in the enactment clauses protects Marylanders from the harms this task force could inflict. Of particular concern is 1F6, which compels the task force to study and make recommendations regarding ways to counter and prosecute online extremism while balancing First Amendment concerns. While the term extremism has become a favored term for politicians across the political spectrum, it's not defined in the bill, and it's generally perceived to mean just holding beliefs outside the mainstream. Finally, so I agree with many of the recommendations about the makeup of the task force. We would urge including members who have expertise in civil liberties, and including representation from public defenders would be ideal. We'd say that if the General Assembly wants to fight white supremacy, they should adopt the strongest police reform measures possible to protect Marylanders from who are most often harassed and harmed by police violence. Thank you.
All right, thank you. Good to see you on Zoom instead of in front of my house where my daughter lives on the weekend. All right. Next up is Mr. McAvoy.
Hello, thank you so much, committee. Can you hear me all right? Great. I urge an unfavorable on this bill. It's alarming. You know, you look at my page 2, line 1. It's talking about Michigan. They're talking about DC. You've got chiming in from a sanctuary city of Hyattsville. The sponsor is up my way. We have gang violence and high criminality, extremely high death rates. And she's talking about developing a task force. This is completely misguided. If we're talking about legality, I think we got that thing cornered. So I'm urging an unfavorable, and I would just say that, you know, it's an insult to our policemen, it's an insult to DHS, it's an insult to the people who are charged with doing this. That we say, well, we need to develop something else, like they're not doing their job. It's just silly to think that Maryland is going to take on issues that have to do with Michigan. It's befuddling. So, and just the fact that we waste time and money on this. If we have issues, we have Maryland State Police. We have a problem, send them over. I don't see what the issue is. They're a phone call away. We don't need a task force on this. And I urge us to focus really on let's get out of this ideology stuff. This is really misguided and divisive. Thank you so much for listening.
Excellent. Thank you, Mr. McAvoy. And with that, that'll conclude the testimony for Senate Bill 864. We'll now turn to the committee for questions. I see Senator Huff has one. Senator Huff, you're up.
Yeah, thank you very much, Mr. Chair. And I guess my question to the sponsor, I mean, it's an interesting bill. I mean, the opposition and just interesting. The one question I have is, so it only, when you talk about domestic extremism, it only mentions domestic terrorism, it only mentions white supremacists, which actually I think it's good that we condemn them. I think it's good in the resolution. I'm sure you'd have all 47 senators gladly condemn them. I condemn them, they're awful. But I'm looking at the reports that are cited from DHS, and they also mention, they probably mention that white supremacist groups are a problem. But they say federal authorities have been warning state and local officials since 2016 that leftist extremists known as Antifa have become increasingly confrontational and dangerous, so much so the Department of Homeland Security formally classified their activities as domestic terrorist violence. And they warn a likelihood of lethal violence between left-wing anarchists and right-wing white supremacist and nationalist groups. And they have all kinds of examples here. In Texas capital of Austin, armed Antifa protesters attacked Trump supporters and groups at several recent rallies, then swarmed police in successful effort to stop them from making arrests. Quote, both the racist segment of violent Antifa counter-protest are ramped for battle in an escalating arms race. And so again, there's anarchist groups have become so aggressive, including making armed attacks on individuals and small groups. Some Antifa activists have gone overseas to train with fellow anarchist organizations, Turkey. And so, I mean, in Portland, DHS talks about 50 straight nights of criminal violence, which is primarily Antifa. And even in the Department of Homeland Security threat assessment that you pull part from, they do mention that these white extremist groups or white supremacist groups are obviously a threat, but then it leaves out basically these left-wing anarchist groups. So would you be opposed to making sure we include both the white supremacist groups and the Antifa left-wing groups so that we get all types of the violence? Because you remember when we started off of this session, I talked about having seen both sides of it, that the extremists on both sides, on the right and the left. And I guess I'll wrap up by saying that the only real extremist side that we've been seeing recently and that members of this committee have seen have been from the left-wing side. So would you be opposed to adding anarchist and Antifa to your resolution?
So let me start by saying that I am not opposed to making clear that the mission of the task force should be focused on preventing targeted violence wherever it occurs. But I don't know where you were reading from, but I even think that the national experts, and maybe Dr. Braniff can comment on this, but I think the threat from one side far surpasses the other side. But again, as I said, I'd be happy to make it clear that preventing targeted violence from wherever it stems should be the mission of this group.
All right. Looking right to see Senator Cassidy has a question.
Yeah, thanks. I guess my questions are for Mr. Braniff. I'll start, although I would like to thank Mr. Grimes for his views that he expressed. I find myself strangely attracted to activists from Tacoma Park today, but that's okay. But Mr. Braniff, if I could, I'm curious because, based upon the dialogue we just had between the sponsor and Senator Huff, do you agree that that the threat here is not isolated to a particular ideology, that it's extremists on all ends of the political spectrum, or is this, in your view, truly a white supremacist issue?
Thank you for the question, Senator Casilli. So at our organization, we look at any perpetrator of extremist crime, regardless of ideology. So what gets you into our data sets is your behaviors. If your behaviors warrant inclusion, then we'll look at motivation ideology. So we're agnostic as to, okay. Right? And
maybe we should focus on the definition first, and I thank you for that. But so it's countering, are we talking about, I think the bill talks about preventing domestic terrorism. Is what your database reflects is domestic terrorism? And if that's the case, how do we define terrorism?
Sure. So we have multiple different data sets, including those that look at terrorism, as well as those that look at other things like hate crime. So I was drawing from both in my brief testimony. Terrorism is generally understood to be ideologically motivated violence or the threat of violence intended to have a psychological and political impact on an audience beyond the physical target of the attack. So it is, it often involves targeting sort of non-combatants or innocent civilians, although that is not necessarily required. You can still engage in political violence and attack a government facility, for example.
Okay. Since your organization deals with both hate crimes and domestic terrorism, I know this body has done a lot on the hate crime side. This committee, you're in front of at least a couple of bills, if not more, every year on different aspects of hate crime legislation. So, but I don't see that as the focus of this bill. I see this as the terrorism side. Do you agree with that? Is that what we're talking about in our discussions here today?
That is the bill as written. I would recommend a holistic approach because I think that in reality, ideologically motivated violence spans a spectrum. And I think it does us a disservice if we try to rationally allocate our resources, but we divide up the data into somewhat arbitrary categories. So if a ideologically motivated individual conducts a hate crime, but they're in the same social networks online, the same social networks in person, as someone who goes and conducts an act that we say legally is terrorism, the solution to preventing those two different attacks might be very, very similar if we just allocated resources to them. And I think the problem is if we ignore hate crime when we're thinking about resource allocation, we're literally ignoring 8,000 to 9,000 instances nationally in order to allocate resources against 60 or 70 instances, right? And that doesn't seem to make rational sense to me. So I would actually encourage considering them together from an empirical standpoint, and then recognizing that there may be different responses to the different kinds of violence.
Yeah. So would there be a benefit? I mean, I generally tend to think of countering domestic terrorism as something that is best focused at the national level, since people who engage in domestic terrorism, in my knowledge, don't consider themselves, oh, well, I'm a Maryland domestic terrorism guy, or I'm a Pennsylvania domestic terrorism guy or gal, that they kind of don't recognize state borders. So I'm kind of surprised that we would, I mean, I've just assumed that this is best off dealt at a national level by groups like the FBI and national folks. But
there are
something at a state level. Why?
Excuse me. Thank you. There are opportunities at the state level that don't exist at the federal level in terms of passing legislation unique to domestic terrorism. Right? In the U.S. Criminal Justice Code at the federal level, there is a definition of domestic terrorism, but there is not a punitive charge. So the FBI literally cannot arrest someone and charge them with domestic terrorism. As a result of the lack of a punitive charge at the federal level, approximately 62% of violent domestic plots succeed in killing or injuring someone. 62% success rate compared to 24% for international terrorist cases in which there is a punitive charge that can be used to disrupt a violent plot before it happens. So at the state level, though, we have the ability to have domestic terrorism related laws that could give law enforcement, but also empower communities, schools, mental health professionals, others to do disruptions before someone engages in a crime, including a violent crime. So I actually think there is a real opportunity at the state and local level to address a federal gap that is systemic and significant.
I think I see some of the advocates shivering as you're talking about expanding this, but I won't go there. At this point, this is based upon terrorism. Do you know the numbers of folks in Maryland that have been killed or injured by domestic terrorism?
Not off the top of my head, Senator. I'd be happy to get you that answer.
Would I be? I mean, I don't know of any. I mean, the last ones that I feel pretty certain would have been Malvo. The ones that Malvo, John Lee Malvo, whatever, was involved in, was clearly a case of domestic, at least in my view, domestic terrorism, trying to terrorize the entire community for sort of sick political aims. But I'm just trying to think of another example of a death or serious injury in Maryland caused by domestic terrorism.
Yeah, I mean, 2 years ago on my campus at University of Maryland, a white supremacist murdered an African-American college student.
Yeah, and that was clearly a hate crime, and we actually had those folks come in and testify, the family, and it was a horrible case. But that was, I don't think, we even had the prosecutor talking to us. I mean, clearly that was a vile hate crime, but there was no indication that person had any intention beyond just being a hate-filled individual, which I guess leads into your suggestion that we not isolate this to terrorism.
Yes.
I mean, when I look at this, and I look at that in Maryland in 2019, we had 27,000 violent crimes, 117,000 property crimes, 542 murders, and 1,900 rapes. And I realized that then when the Homeland Security chief comes up and says that white supremacy is this, existential issue that we have to address, he's talking about specifically, I think the words that he used were, when we talk about violent extremists, so it's only the political side. So people trying to achieve political aims through violent means, that's what he was referring to. But clearly there's a much bigger problem. You said, somebody referred to, well, do you know what the numbers are in the US on domestic terrorism as opposed to just hate crimes?
So in terms of number of plots, again,
or deaths in US wide in the last couple of years on domestic terrorism?
Yeah, so they're in the tens. They're less than 100 deaths per year in terms of terrorist attacks. But I think it's important for us to recognize, and I fully understand that terrorism is a rare phenomenon compared to other forms of crime. The challenge, though, is that terrorism tears at our social fabric. It's intended to have a psychological and political impact that's larger. So if you use body count to think about terrorism, I think you're actually missing the fundamental nature of the threat, right? The threat is intended.
And I agree with you. I think that was Senator Huff's point, was that if we ignore body counts and look at the impact that certain groups have had on trying to use violence to achieve political aims, that to suggest this is a white supremacist problem really misses the mark by a wide range, because Antifa has certainly had a huge impact in this nation over the last 5 years in directing, achieving political aims and beating people coming out of the White House and the like. I mean, after the Trump inauguration, the smashing windows and beating people, and of course, none of them were ever prosecuted. But I think that was his point, that we can't just count body counts here, that you can achieve terrorist aims by just simply beating and terrorizing people without killing them. And that's your point.
Senator, I would just say that empirically, based on a nonpartisan, objective collection of data from across the United States, there is almost no comparison between the level of violence, including property violence, between Antifa and groups like the militia movements, the skinhead movements, the neo-Nazi movements, the self-proclaimed alt-right, that just in every category, they are the most dangerous. And ADL's data, I think, would support that. So I'm not trying to make a political point at all. That's just what our findings tell us.
Yeah.
Is that
I'd love to see that, because certainly that's from a standpoint of just sheerly of disrupting the political atmosphere in the nation and achieving political aims through violence and intimidation. I just find it remarkable that after the Trump inauguration, when people are beaten and things are smashed and people are run out of the city, that's not a problem, no political aims here. But yet when the same thing happens with the Biden administration, that's a national catastrophe. I mean, at some point in all this discussion, I think intellectual honesty has to reign supreme, and that's why I appreciate the gentleman from Tacoma Park and his views, which really suggest that, hey, this stuff can be run amok, and this sort of becomes the 1960s hearings on, or I'm sorry, 1950s hearings on communism and stuff, and that we end up using the security apparatus of this state to achieve purely political purposes, and that ought to scare the heck out of everybody, because honestly, I think those witnesses who testified to concerns on that front certainly struck a chord with me. But thank you very much. I appreciate your testimony. Thank you, Mr. Chairman.
Thank you, Senator.
And thank you, Senator Castley. Senator Castley and Tacoma Park mobilization. Strange bedfellows indeed. I never thought I'd see that one. All right. All right, looking around the room for additional questions from senators. All right, 2021. Anything's possible here. All right, with that, that'll conclude the hearing for Senate Bill 864. Thank you, Senator Hettleman. We'll now move on to Senator Carter with Senate Bill 898. Senator Carter, you're up.
Thank you, Chairman Smith and members of our committee. I promise to be as brief as possible because this is a beautiful day and there's one bill after this between us and the sunshine. So I'm very excited about this bill. I realize that we've already done a lot of heavy lifting this session, and this is quite an ambitious bill, but it's an important one. Senate Bill 898, the Maryland Criminal Justice Debt Elimination and Prevention Act, is an important bill for us to consider, as we have indicated that we're serious about the eradication of the criminalization of poverty. And so this bill seeks to eliminate those kinds of gripping fines and fees that keep people in a perpetual situation of being unable to kind of free themselves from the long arm of the criminal justice system because they aren't able to pay debts and fines and fees imposed by the criminal justice system. Now, some of the aspects of the bill we've already looked at in some other bills this year. One is looking at our pretrial system and the fees associated with the GPS monitoring for pretrial. Another aspect of the bill deals also with child support and the fees associated with the driver's license suspensions and driver's license issues around that. I've spoken with the advocates and proponents of the bill, and they've expressed a desire, and we're going to have amendments drafted to take that part out of the bill because, one, we're dealing with it in another bill. It also is the area that created the greatest opposition from the Department of Human Services because they had a real issue with that part. But all of that being said, what does the bill do? Well, the first really important thing that you need to understand is that the bill requires an indigency determination when assessing fines and costs for defendants. And that's important because it doesn't seek a wholesale elimination of fines, fees, and costs. It simply tries to assess them based on what a person can actually afford to pay so they aren't cast into a situation where they're having to choose between a mandated court cost versus paying for their housing, their medication, or other great needs. And so I'm not asking that we eliminate the consequences of wrongdoing, only that we stop criminalizing poverty. And this bill does exactly that. What my chief witness, Corey Johnson from Job Opportunities Task Force, will walk us through the chief aspects of the bill. It's a long bill, but I don't want this committee to be, feel defeated because of the fact that it's a lot to read, because it's really pretty concise in what it does and the ways that it seeks to take away some of the fines and fees. So keeping people imprisoned by debt long after they serve the sentence is something that we should have as a goal to alleviate. For those reasons, I'd urge a favorable report.
Well, thank you, Senator Carter. And I have as your primary Ms. Johnson from JOTF. You're up. You have 5 minutes.
Good afternoon, Mr. Chair, members of the Senate Judicial Proceedings Committee. For the record, my name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force, where our mission is to promote policy and programs that increase the skills and job opportunities of low-income workers and to eliminate barriers for meaningful employment. I would like to start by thanking Senator Carter for her timely introduction of Senate Bill 898, as now more than ever during this time of economic uncertainty, protecting the financial interests of our most vulnerable populations is extremely important. The Fifth Amendment, incorporated through the 14th Amendment, requires that no person should be deprived of life, liberty, or property without due process of the law. Yet 36,000 Marylanders a year are plagued with thousands of dollars in fines and fees, many of whom have never even been convicted of a crime. These fees for service include court-related fees, home detention, parole and probation, jail room and board, mandatory drug and alcohol testing, vehicle interlock device fees, criminal record expungement, as well as interest and late fees from the Central Collections Unit. To concretize the lived realities of citizens across the state, I would like to highlight the exact dollar amounts to give the committee real-time numbers of what individuals are paying. Jail room and board costs vary, but ultimately equate to days spent in jail with laundry and food. Court fees also vary. Last month during our JOTF bailout, we bailed out a client who was held in detention since December because he failed to pay $157.50 in court fees, which was considered a violation of his probation. Electronic monitoring costs approximately $10 to $20 a day, which is approximately $300 to $400 a month, not to include the activation fee. One of our coalitional partners, the Baltimore Action Legal Team, in the year 2020 paid $160,000 for about 130 individuals on electronic monitoring alone. The predatory nature of these are damning for our most vulnerable community members, as they are disparately impact racialized minorities and those living below the poverty line. In 2018, a University of Washington sociologist estimated that 80 to 85% of individuals leaving prison owe criminal justice fees, which estimates to about 10 million Americans who owe more than $50 billion in criminal justice debt. This has also led to the criminalization of race. I would like to remind the committee that the Vera Justice Institute reported that Maryland leads all other US states with the criminalization of Blacks. Despite Black Marylanders only making up 30% of the population, 70% of our prison population is Black. The predatory fee system has led to a parasitic cycle of exploitation whereby the state places the financial burden on citizens to fuel the fiscal agenda of the Maryland criminal justice system. To use the city of Ferguson as an example, in 2015, the DOJ reported that the revenue generated from the collection of criminal justice fees made up $3.9 million out of a total of $11.7 million in general revenue. The practice of funding an entire city on the backs of citizens is not only morally bankrupt, but unconstitutional. Grover Norquist from Americans for Tax Reform indicated that a key reason Ferguson police were despised is that elected officials had turned police into tax collectors for the city, not sales tax or income taxes, but fines, fees, forfeitures, and traffic tickets. In Nelson v. Colorado in 2017, the Supreme Court held in favor of an individual who was forced to pay exuberant fees despite being found innocent. In the majority opinion penned by late Justice Ginsburg, she indicated that per a due process right, an individual maintains a presumption of innocence, and as such, requiring fines and fees is unconstitutional. Now, I would like to also address some of the preliminary concerns that the committee or opposition may have in regards to this bill. First, I'll address the elephant in the room, as many of you are probably asking, well, how are we going to pay for this? I would like to reiterate, there is no price tag on justice, and a presumption of innocence is guaranteed by the Constitution. Secondly, the functionality of the criminal justice system is a duty of the state. Similar to the education system or sustaining highways, if the state of Maryland believes that the functionality of the criminal justice system is necessary and important, then everyone should pay for it. Lastly, any opposition that would suggest that this could cost the Department of Public Safety $10 million, I would like to reiterate that the fiscal stability of the essential functions of a government agency should not rest on robbing the poor of millions of dollars. Protecting Marylanders from these predatory fees is not robbing the department. Instead, the department has arbitrarily structured its source of revenue from taxing the indigent and people of color. I know that Senator Carter indicated that the legislation does seem tedious. It is 40-something pages. However, the complexities of this bill are minimal. SB 898 seeks to eliminate fines and fees that are associated with an individual's interactions with the criminal justice system. It's doable. The state of Illinois just became the first state to completely eliminate all criminal justice fines and fees. We are hoping the state of Maryland can do the same. For the reasons above, we urge a favorable report.
Thank you, Ms. Johnson. We'll now move on to Mr. Westry. You're up. There you are.
Got it. Thank you. Mr. Chair and distinguished members of the committee, I thank you for this opportunity to testify today. My name is Philip Westry. I am a staff attorney at Maryland Volunteer Lawyer Service. I am a part of our organization's workforce development group. Our group chiefly focuses on removing barriers for low-income Marylanders seeking employment opportunities. especially after long periods of unemployment, underemployment, and post-incarceration. I'm currently providing legal assistance to folks who are doing contact tracing and COVID-19 response coordinated through the Baltimore Health Department. I'm here today to respectfully give you all my reasons for supporting Senate Bill 898. First, I'd like to tell you all a little bit about a client of mine whose story is very common to the folks that we serve at Maryland Volunteer Lawyers. His name is Tom. I met him through his work with the Health Department of Baltimore City. He is a COVID-19 contact tracer. One of the things that I'll tell you about Tom is his journey to get to where he is now is like many Marylanders, specifically many Baltimoreans. When he was younger, he was involved in the criminal justice system. He was eventually incarcerated. But upon release, he spent many years working in doing gang intervention work in Baltimore City. Tom knew that this work was important because he was trying to help folks avoid the situation that he found himself in. But when Tom was released, he found himself in a situation where he ended up paying the state of Maryland over $5,000 in costs related to his time in the justice system. Those fees were related to home monitoring, parole fees, and mandatory drug testing. I won't go over all those fees because I think Corey did a great job of going over those different types of fees. But here's the thing: for somebody who is lower income or indigent, those fees can add up quickly. Some start off small, but others cost anywhere from $300 to $400 a month. And here's the thing: my client was like many Marylanders, needing to pay for food and housing and healthcare and childcare. And he ultimately told me that he was in a situation where he was trying to figure out whether he was going to pay the fees related to his incarceration or the money that he needed to pay for child support, at least to pay it in full. And then, thank you. For these reasons, folks like my client and folks that we serve at Maryland Volunteer Lawyers need this bill to have a favorable report. Thank you. I appreciate the opportunity to speak to you all today.
Excellent. Thank you, Mr. Westry. Thanks. And next we will go to Ms. Jones.
Hi, good afternoon, everyone. Thank you to the members of this committee for allowing me to testify today in support of Maryland Senate Bill 0898. I would especially like to thank Senator Carter for the leadership on this bill. My name is Priya Sarthi Jones. I'm the National Policy and Campaigns Director at the Fines and Fees Justice Center. FFJC is a national advocacy organization which seeks to end the use of fees in the criminal justice system and administer fines in a more equitable way. The use of fees in the criminal justice system is a form of regressive taxation. Rather than paying for our criminal justice system through general funds and budgets that support the needs of the system, we charge those costs to those who are unfortunate enough to have contact with it. In many places, these fees charged don't even go to the system itself, rather other non-related government needs. Oftentimes, it is brown and Black residents and low-income communities that bear the burden of this structure. A movement to end fees in the criminal justice system is starting to take hold in this country. There are many examples of jurisdictions ending certain types of fees. Just this past summer, California ended charging 23 of its most egregious fees in the criminal justice system. New York has launched a campaign to do something similar and end various fees and surcharges. Maryland understood the importance of this issue and ended this practice in the juvenile justice system just last year. Maryland passed the most comprehensive juvenile fine and fee repeal that has ever been passed anywhere in the country. SB 0898 is a great bill that seeks to make the criminal justice system more equitable and less disproportionately punitive on those who can least carry the cost. Passing this bill would make Maryland a leader once more, setting an example to other states that there is a better and more just and fair way to administer our criminal legal system. A system that benefits society should be carried by all of society, not just those of us who find ourselves part of that system. This is a principle that we apply to all other essential systems such as education, roads, infrastructure. When the government deems it essential, then the government and all the people must be responsible for it collectively. Ending these fees and establishing a better and more reliable funding structure is our path forward. The question is always asked, but how will we pay for it? But I do not think that's the right question to ask. Someone is already paying for it, disproportionately Black, Brown, and low-income communities. The real question isn't how, it is who, all of us or just some of us. I encourage this committee for a favorable report. It will make a huge impact in the lives of Maryland residents and keep Maryland moving in the right direction. Thank you for the opportunity to address this bill, and I look for the Fines and Fees Justice Center to express its support in this policy shift.
Thank you, Ms. Jones. And next we'll go to the final witness for the panel, Ms. Hanson-Mundell.
Good afternoon, Committee Chair, Mrs. Smith, and the other committee members. Thank you for having us. My name is Nicole Hanson-Mundell. For the record, I am the Executive Director of Out for Justice, a nonprofit that advocates for the very individuals who we speak of today. You know, most of my colleagues really highlighted the numbers, right? How important it is for us to ensure that every Marylander has access to prosperity and liberty and should have access to rebuild their lives and not be imprisoned by debt, right, every day. But I actually get to hear and even have been impacted by these fines and fees that just not only prohibits us from having access to food and housing and just be able to take care of our daily necessities, but it also has this very mental component to it. It is very, very stressful for, let's take a guy like I'm dealing with this month, Brian, who was a city worker, who went out, hurt his back job. At the time, he was only making $10 an hour, right? So you can almost calculate how much that is a year. I mean, after a night of stressing out about his mother's death, he caught a low-level resulted in administrative fines, right? And so he was without driving for almost 2 years. He had to have the interlock in his car, but because of his disability with respiratory issues, he couldn't really blow in the machine. And it took almost 2 years back and forth to figure out how he could kind of start over, recoup his money. He was without his driver's license for 2 years. He even paid so much money to the interlock program. And oftentimes he had to struggle with, okay, I'm not getting my regular paycheck anymore. How am I going to pay this interlock fee? How am I going to be able to have access to transportation and take care of my grandkids and go to the store like I need to, because he lives in a food desert. So there's no markets near him, right? And so I just want you all to think about how this not only impacts one's ability to really prosper in life and get out of debt, but it also has a very mental breakdown. I myself, an impacted woman, I'm still dealing with the repercussions of a mistake I made over 5 years ago. My debt that I was imposed is now in collections. And so that alone, stops me and hurts me from home ownership and impacts my car insurance. It impacts every part of my life, right? And many of these fees we shouldn't have to pay. We can't afford it. And there are ways in which government could accommodate these fees. Is my 2 minutes up?
Yeah, it's up. Just if you could briefly conclude. Yep.
Yes, sir. So I just want you all to consider that you have family members and friends, or you know someone, or someone's in your district.
All right, you're muted. I don't know how that happened here.
These fines and fees, and it causes people to go back into criminality in order to figure out how they're going to cover these fines and fees.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 898. Turn to the committee for questions. Seeing none, that will conclude the hearing for Senate Bill 898. Thank you very much, Senator Carter, and thank you to the panelists. Have a good afternoon. We'll now move on to our final bill of the day, Senate Bill 910, which is me. So Members of the committee, this is Senator Smith here to present Senate Bill 910. First, before I get started, I want to thank Delegate Wilkins for her hard work on this bill and on this issue. She's my delegate, represents me in the House of Delegates, and she has been a champion for renters' rights and for housing protections and relief, especially in the midst of this pandemic. So, Senate Bill 910. Obviously, we're still in the midst of the pandemic, and although some restrictions will be lifted in the next few days and weeks, we still have the state of emergency, and there's an eviction moratorium. But once the moratorium is lifted, the courts will, we expect to see, and you've heard a lot of an impending eviction avalanche. Nearly 40% of Maryland residents either lease or rent their home. And so the moratorium only applies to cases where a tenant can prove that failure to pay rent was actually due to a loss of income that was connected to COVID-19. And so it also restricts foreclosures on residential properties as well. And you know that the courts have begun a phased-in reopening, and now we're currently in phase 2 until March 14th. And so the district courts can hear rent escrow actions. They can do emergency breach of lease involving threats or injury to people or property and associated with warrants of restitution. They can do emergency wrongful detainer actions, emergency tenant holding over actions, and so forth. Despite the protections and despite the moratorium, evictions have actually continued. There have been about a little bit north of 2,500 evictions in Maryland between July and November of 2020. And in August and September alone, there were 233 holding over cases that were filed in the Baltimore District Court, which is an 82% increase in activity from the same 2-month period just the year before. Tenants with short-term leases are facing evictions since landlords are opting not to renew their cases. The landlords often don't need to wait for these leases to end before they start legal action, as landlords file notice to non-renewal to tenants, generally between 30 to 60 days before the end of the lease. So the estimates, looking at some of the research that Delegate Wilkins provided, estimates provided that by Stout, it's a Chicago-based consulting firm, found that there were between 194,000 and 244,000 households in Maryland that are currently at risk of eviction. And their combined rent shortfall is about $381 million. So what this bill does is it's a very comprehensive and bold approach. It requires the Department of Housing and Community Development, DHCD, to compile, maintain, and publish data on its website, eviction-related data on its website. Requires sheriffs and consulates must provide a written notice of an eviction to a tenant or subtenant at least 48 hours prior to executing the warrant of restitution for residential property by posting that notice on the front door of the premises. They must also collect the eviction data and provide that to DHCD by the end of every single month. It requires DHCD to establish a fund for rent forgiveness and eviction prevention efforts. It implements several requirements before landlords can actually proceed with the eviction. It establishes an eviction moratorium for residential leases during the state of emergency. It creates a Know Your Rights program that educates renters and landlords of their legal rights during an eviction proceeding. And then following the conclusions of the eviction moratorium, landlords must not evict tenants unless there is just cause. Tenants can use substantial loss of income as an affirmative defense during these proceedings. Again, it's a multi-pronged approach. Landlords may not file failure to pay rent if the tenant owes less than $600, which is including any late fees or utility bills. And prior to filing a complaint for the repossession of residential property and a failure to pay rent, landlords must deliver notice to tenants, and it must include certain specified information, which is enumerated in the bill. So this is a very comprehensive and bold approach in an unprecedented time. I'll kick it off to Mr. Shaw, who can provide you with some context and kind of ground truth of what's actually happening in our communities. And with that, I'll ask the committee for a favorable report, and I'll turn it over to Mr. Shaw. He's my primary witness, and he'll have 5 minutes. Mr. Shaw, over to you.
Thank you, Chair Smith and Vice Chair Waldstreicher, members of the committee. My name is Zephyr Shaw. I'm an attorney in the Human Right to Housing program at the Public Justice Center. And our organization is part of the coalition Renters United Maryland, which is made up of over 30 organizations across the state that support and advance the rights of renters and protecting tenants from housing instability. When it comes to eviction protection in this COVID-19 emergency, we know fundamentally that housing is a tool of public health. And this committee has only one bill before it this session that sets out to provide immediate help that ensures tenants will stay housed during the crisis and during the economic recovery. There are many good bills that you are leading on, not least of which is the right to counsel bill and the fee increase bill on evictions. But I want to stress that this bill is absolutely necessary for immediate housing protection for renters across the state. Senate Bill 910 is necessary because the status quo has failed thousands of renters and many renter households, and many of those households continue to face the jeopardy of eviction in the coming months. As the chair just mentioned, there were over 2,500 evictions just last fall, and there are 117,000 eviction cases pending in the courts that were filed last fall and then put on hiatus, so to speak, because of COVID-19 protocols that end next week. This data about the filings, the increase in tenant holding over cases that is now documented, make clear that Maryland has not had a true moratorium on evictions. And what we've called a moratorium for all this time is really a patchwork of limited protections. Governor Hogan's executive order, the federal CDC order temporarily halting evictions through March 31st, as well as the Maryland judiciary's administrative orders partially closing eviction dockets. And under this patchwork approach, the moratorium has existed as really the trial defense, not a moratorium. And so notwithstanding the dangers of the pandemic, tenants have been summoned to court. They have not been notified of an option to participate in remote proceedings at court. If they were unaware of the trial defense, the court very likely entered a judgment for possession. If the tenant was aware of their trial defense, they had to prove that Governor Hogan's executive order applied because of a substantial loss of income related to the pandemic. And in the case of the CDC order, that they provided the landlord a declaration ahead of trial. And then at the trial, they had to prove the veracity of 5 different elements in the declaration. And that has by no means been easy for unrepresented tenants. And notably, where tenants did succeed in using the trial defense, eviction was merely delayed, leaving tenants under immense pressure to self-evict in the meantime. So the patchwork approach has focused on delaying eviction for non-payment of rent, but allowing eviction for lease non-renewal and breach of lease. And my colleagues on this panel are going to speak further about the increasingly harmful use of no-cause lease non-renewal during the pandemic, even as landlords received thousands of dollars in federal aid. But let me preface by saying that a landlord with a month-to-month tenancy has been and will continue to be free to non-renew their lease during the pandemic and to evict for tenant holding over, even if the tenant has caught up on rent, as long as the governor's affirmative defense scheme is the law. We absolutely have to have SB 910 passed to close that loophole. There simply is no other existing protection that restrains landlords from exercising that power. So SB 910 proposes a full spectrum of emergency eviction protections. The moratorium in this bill closes the loopholes. It provides trial defenses after the emergency based on substantial loss of income to cover all 3 actions that tenants face for eviction: failure to pay rent, tenant holding over, and breach of lease. I want to add that the bill, when being drafted, was intended to allow an exception that allows for eviction when a tenant poses an imminent danger. And I further want to emphasize that the protections in SB 910 do not restrain landlords' rights to evict illegal occupants under the wrongful detainer statute. This bill does attempt to achieve the strongest protection while also not unduly harming the rights of landlords. I just stress lastly that we have to do more than what the executive branch has done. Your constituents have struggled during this time. They need the Senate to pass a real protection in Senate Bill 910. We urge your favorable report. Thank you.
Excellent. Thank you, Mr. Shaw. And next we'll have, there you go. Lisa's up. There you go. Sorry.
Good afternoon. Thank you, Chairman Smith and the committee members. My name is Lisa Sorrow. I'm General Counsel with Arundel Community Development Services. We are Anne Arundel County's nonprofit housing and community development office. Among the many things that we do at ACDS is administer the county's emergency rental assistance program. We administered the funds that came in through CARES all of last year. And right now we're rolling out the emergency rental assistance program using the money that was appropriated in the Consolidated Appropriations Act from late last year, early this year. As you know, Maryland brought in about $400 million for rental assistance. Anne Arundel has 17 million of those dollars. Other counties have proportional shares. If we are to use that funding to actually ensure that tenants are not evicted from their housing, we need some protection and for those tenants, assurance that they will not be evicted as soon as we pay their back rent. I think you said there's about $380 million in back rent owed right now. The money that the state has now could potentially cover that, but it can't cover it if if tenants are sued and evicted before we can get to them to provide them with the emergency rental assistance. And also, if landlords are able to evict despite payment of the arrears that are owing, that doesn't do what the funding is there for. That gets the landlords paid for back rent, but it does not ensure that the tenants will continue their residency where they're living. The tenant holding over protections in this bill, at section 6 and 7, the tenant protections would go a long way to ensuring that landlords actually get paid, because we'll have time to get to them before tenants are evicted. And then it will also ensure on the other side of that those tenants aren't evicted just as soon as we pay the arrears. And just to give you a real life example, and I realize that not all landlords would do this, but as usual, one bad apple makes it bad for everyone, makes everyone look bad. We paid one landlord in December last year, December 2nd, paid over $7,000 in arrears. And I learned a couple of weeks ago that landlord filed a tenant holding over action 2 days later. 2 days later. It's happening, and we would like your help to prevent it from happening further. We urge your favorable report on this bill. Thank you for your time.
Thank you very much, Ms. Sorrow. And now we'll move on to Greg, Mr. Countess. I saw you there. There you are.
Yes, sir. Thank you very much, Senator Smith, Mr. Chairman, Mr. Vice Chair, members of the committee. I'd like to thank you again, Chairman Smith, for introducing, really sponsoring this bill on the Senate side, and of course for the work of Delegate Wilkins. If I can, my testimony, again, my name is Gregory Callis with Maryland Legal Aid. Let me formally introduce myself. I'm a lawyer there. The point that landlords during this pandemic who felt that they were stopped from collecting their rent and therefore needed to use the 8-402, we commonly call it the tenant holding over statute, in order to evict tenants, is one that's documented by those statistics that Chairman Smith recited. And I'd like to give you a real world example of that. On December 30th, there was a column or an article in the Baltimore Sun, and it's about a building called the Copycat Building in Baltimore City, about 98 units of property. And as a matter of fact, this landlord had perhaps perfected the use of the tenant holding over a statute in order to collect or threaten tenants to sort of get their rent, or if they were displeased with the resident to evict them pre-pandemic. And this only accelerated during the pandemic itself. Because this landlord was unlicensed, and in Baltimore City, if you're unlicensed, then you can, and under state case, which Ms. Sarah is familiar with, Baranowski, the landlord cannot use the failure to pay rent action in order to collect rent if they're not licensed. And this landlord discovered that, well, I can use perhaps, because there hasn't been any court decision on that, the tenant holding over statute. And this is what Judge Wilson of the district court said. And this was a case that was filed during the pandemic. Here's where I am in this case. It's interestingly enough, not in rent court, but in tenant holding over. Clearly based on the lack of a rental license, I can surmise it was done to avoid rent court. And he goes on to say that if these licensing laws, there's reasons why these laws were created. Okay. And frankly, what he said there and what he demonstrated in that case is sort of directly analogous to what landlords have done with the prohibitions and the barriers to evicting people through the failure to pay rent statute or cause of action. Landlords have instead used the tenant holding over statute in order to effectuate those evictions. And we would ask, therefore, for a favorable report on this bill. Thank you very much.
Thank you. Next, we have Ms. Martinez. You're up next. Yep. Ms. Martinez, I'll try to unmute you here. Try one more time. Okay, so there you, I think you're good to go. Ms. Martinez, can you hear us?
Yeah, I can hear you guys.
There you go. Okay, great.
Hi. I'm going to start off by saying good afternoon to all the senators. My name is Carla Martinez. I am 16 years old and I'm a student at Bladensburg High School and a CASA member. I am here today in support of Senate Bill 910 because every day I worry about our family and neighbors losing their homes. I live in Riverdale, Prince George's County with my mom and my two younger sisters who are 8 and 13 years old. The pandemic has hit our family very hard since it started. My mom is a single mom and she lost her job more than a year ago in February 2020. She hasn't been able to find a stable job to this day. Her savings are completely run out and she hasn't been able to pay. Can you hear me?
We can now, yes.
Okay. Do you want me to repeat what I said?
Oh, no, I think we missed a couple of seconds, but please keep going. Thank you.
Okay. The leasing office has threatened us multiple times with eviction. Many of us got several letters saying that we have to leave within 30 days. The letters were all in red paper to intimidate us. The threats have caused many of us to lose sleep and caused a lot of damage to our mental health. At night, I hear my mom stressing and wondering what she can do to keep us from becoming homeless. It's just not the parents who are working that are affected, it's us children as well. We reached out to CASA for help and we formed a committee of neighbors facing this crisis. We monthly have meetings to see if there are updates on the going rent crisis and to get information about if we're gonna get help from our government. In just our complex with 170 units, there are 50 families that can't pay their rent. I can't begin to imagine how many families out there in the entire county and state can't pay their rent either. I learned that my
Ms. Martinez, and we just lost you there. Can you hear us, Ms. Martinez? Okay, I'll put her on mute. Then we'll get the staff to text her, and if she can come back to finish the testimony, we'll do that there. But just want to say thank you, Ms. Martinez. Very powerful testimony, and we appreciate you taking the time to be here with us this afternoon. So we'll have the staff reach out to you right now. Okay, so I'm going to move on then to the opposition panel, and we'll start off with Mr. McLaughlin. Is Mr. McLaughlin here? If not, we'll go to Mr. Enton.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. You know, this is a 21-page, and we are signed up in opposition with all due respect to the sponsor. And I did have a chance to discuss some of our concerns with the sponsor yesterday and to bring him up to date on what the House has done. And, you know, I always have operated under the admonition, Mr. Enton, you're in the Senate, don't tell us what the House has done. But the chairman did say that we could talk a little bit about what the House has done on the House cross-file, which was voted out of the Judiciary Committee last night. And Ms. Howard will talk more about that than I will. I'd just like to focus on the bill itself. The bill is 21 pages long of new language and new requirements for owners of residential rental property. You know, they talked about the tenants have struggled. Trust me, the landlords have struggled and have struggled terribly. You know, there seems to be this sense that the landlords want to evict tenants. The last thing a landlord wants to do is to evict a tenant in any circumstance. If tenants are not problems, if they don't cause problems, if they pay their rent on time, no landlord wants to evict a tenant. There's nothing in it for the landlord that evicts a tenant. Why would we want to evict them? It's mentioned that there's $400 million that's out there right now for assistance. And with the bill that passed in Congress yesterday, there's another $400 million coming. So you're going to have $800 million in funds available for tenants to be able to pay their rent. And if tenants pay their rent, there are no evictions, period. There's no reason to evict a tenant that pays his rent. So that's where our focus ought to be. And that $800 million is half of it is here. The other half is coming. And, you know, to use the COVID as an excuse to completely paint the owners of residential property as somehow being inherently evil is just totally inappropriate. We've worked with our tenants to try to keep them in the property, not to throw them out. So I'm sure my time is almost up. I think Ms. Howard can talk a little bit about what the House did. The final comment I would make is this bill contains the just cause eviction language, makes it statewide. That bill just received an unfavorable report for like the fourth year in a row on this House side for Montgomery County. We think that's just an indication of how much in this bill, once again, with all due respect to the sponsor, is inappropriate, and we would urge an unfavorable report. Thank you.
All right, thank you, Mr. Enton, and we'll go on to Ms. Howard. You're up next.
Yes, thank you, Mr. Chair, and good afternoon, Mr. Chair and committee members. Kathy Howard with Regional Management, Inc. I couldn't agree more with Mr. Enton. I just want to give you a snapshot of where regional management is at this point in time. We have a 3% unheard of vacancy rate. Generally speaking, our vacancy rates runs 7 to 10%, but we have a almost 30% delinquency rate, which should tell you something and everything you need to know about whether or not landlords are having a little bit of problem here as much as their tenants. We are, you know, the faring of our tenants is the same. It affects us just as equally to some extent as it does to the tenants. And I just want to share those statistics with you. That's just regional management. I can't even tell you what the broader statistics are. But to Mr. Enton's introduction here, yes, I was on the call last night with as the House debated the cross file of this bill. There are many changes made in this statute, but there are many amendments that I think are somewhat helpful here. But there is one in particular that I think that I need to bring to this committee's attention. Most of the amendments that the House put on the bill, the committee believes that they are essentially following a lot of the spirit and language of the governor's emergency orders. But there is, in particular, this issue of whether or not tenant holdovers, breaches of leases, and wrongful detainers should or should not be prohibited under this bill is really a concern of ours. Mr. Shah indicated that they appear to have no problem with making sure that breaches of leases where there's an imminent danger to landlords and tenants are allowable under this bill is a good start. Wrongful detainers should also be exempted from this bill. That's a good start. But let me tell you about tenant holdovers. Tenant holdovers are not just situations where somebody has failed to pay and the landlord decides to end the lease. A landlord decides to end a lease for many different reasons. Sometimes that has absolutely nothing to do with payment, and that is, I can tell you, things that we have done because there is an unfortunate no meeting of the minds anymore between the landlord and tenant, and it's time for the contract to be over. And with that, I would ask you for an unfavorable report, or at least to take a good hard look at what may be coming over from the House. Thank you very much.
Thank you very much. And no, I saw what the House did. I got the line by line last night, and look, I think we all understand that we're in a very perilous and once in a generation situation here, and so look forward to working with everyone in the days to come because time is short. So we will see what the House finally passes out. Okay, I think that's the last panels. I see that Ms. Martinez may be able to come back in and just finish up her testimony very quickly. I want to allow her the opportunity to do so. Hey, Ms. Martinez, you're back on. I see you're connecting with the audio. And I'm going to ask to unmute you. And there you go. We can see you now. And great.
Yeah, I'm going to start off by saying I'm sorry. I have the Wi-Fi, so I'm really sorry.
No worries.
Would you guys like me to start over?
You can. We've had you probably about halfway through.
Okay. Well, I'll try to start off where I think I left off.
Okay.
Okay. So, I learned that my complex has not renewed many people's leases. I am scared that we could soon be put out on the street, not for not paying rent, but simply because the landlord will not renew our lease. I support our neighborhood committee by calling our neighbors to help them make sure they won't be evicted. I want this bill to pass so I can call them and let them know that help and policies to help us are coming. Senators, please, my family depends on your decision. My sisters and I are only kids. We need to focus on school, but instead we worry every day about being evicted. So I want to thank you guys today, Senator Smith, for supporting this important bill. Members of the committee, please vote yes. Thank you.
Excellent. Thank you, Ms. Martinez, for sticking with us and taking time out of your day to testify and for sharing your stories. Thank you for being here with us.
Thank you guys for having me.
All right. So with that, that was the last panelist. So with that, that'll conclude the testimony. Look to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 910. We will be at work soon on this. So, all right, with that, that'll conclude the hearings for the day. And we will see each other tomorrow. So have a good evening, and we'll be in touch.